Everyone join fast. So thank you very much, everyone. A very happy Teachers' Day also to all your teachers. So without any waste of time, this is not the time to. I really understand your love and affection, but still there are exams. So let's focus first on that. I'm very thankful for having all of you. But I will be more happy if you qualify and come to final. Okay. So let's focus on that. So please, everyone, please tell to your friends also, share this to your friends. Ask them to join fast, please. 2 to 3 minutes we will begin. Ask everyone to join faster, please. So this revision is on, as you see in the poster, this is the 4 important chapters that we are going to discuss now. So I'm from SS Academy. Thank you very much. My regards always for that. So listen, we are now going to do the revision of 4 very important chapters. Number 1 will be deposits or incorporation. Next one is the deposits. Next one is the registration of charges. And fourth one will be foreign company. 1000% every attempt, at least 15 to 20 marks are coming from this area. Students are consistently losing marks. That's the reason why they are not getting good marks in the exam. Clear? Everyone will tell that general meetings is important chapter, share capital is important chapter. But what's in these chapters have done? Incorporation is very important for your exam. You should recognize that. Second one, deposits, last attempt registration of charges came for 14 marks, blast on face. That's why paper is said to be tough at that time. Understood? So therefore, please don't be under wrong impression. Something is important, something is unimportant. Everything is important for your exams. Just 2 minutes, I will begin the session. So if your friends are still there, please inform them to join fast. We'll begin. Shall we begin? Everyone, shall we begin? Yeah. So let us begin now. Before going into that, let me just give you the overview of what we are going to discuss from the exams point of view. There are 4 chapters, as I said: deposits, charges, incorporation, foreign company. These are the 4 chapters. In these 4 chapters, don't again make any selective study. We are going to read almost all important concepts in this particular area. Okay. So first, let me start with the area called as deposits. What is the concept? Deposits. Students generally leave the chapter. They will ask in examination for a good amount of marks. Please do not take any kind of risk in this. So let us begin. So first one, chapter we are going to start is deposits. Listen, deposits chapter, there are 2 very important concepts. Number 1, what is not a deposit? Number 2, rules for acceptance of deposit. In this again 2 parts, 73 section, 76 section. 73 section will be talking about asking the deposits from members, means companies accepting the deposits from members, and 76 is talking about acceptance of deposits from public, not being the members. So these are the 2 very important sections along with not a deposit. Okay, remaining sections are just penalty sections, read and leave. Main concepts we are going to discuss now is what is not a deposit. 73, 76. 73, 76 is 80% similar, 20% dissimilar. At 20% dissimilar, we have to understand. Everyone clear? Everyone in the class clear? Shall we begin? Yeah. So let's begin. Let us start. So see here once. First one, acceptance of deposits by company. Acceptance of deposits by company. First one, follow properly, listen carefully. 2 things you have to do because exams are very near, just 1.5 day after. At this time, please don't be jovial. Wherever you find any important point, note it down somewhere. Okay, and anyway, the video will be available, you can listen, but still concentrate. Applicability of this chapter. Deposit provisions are not applicable to following companies. First point, a clarity. To whom this chapter does not apply? Banking company this will not apply. NBFC, housing finance, or any other notified central government notified companies. Question is on why. Why they are not applicable? Banking companies will accept deposits not as per Companies Act. They will accept deposits as per their own act. SBI under SBI Act, other banks under the Banking Regulation Act. They follow banking law beyond company law. That's what we discussed in section number 1 in our regular class. What section 1 of Companies Act will tell? Section 1 of Companies Act will tell that Companies Act is applicable for banking companies, insurance companies, electricity companies, and other notified companies also. However, if there is an inconsistency, Companies Act will not prevail. Those acts will prevail over the Companies Act. From this, what is the moral of the story? For banking, NBFC, housing finance, and other notified central government companies, for them a separate law is already applicable. Since deposits of banks are not accepted as per these rules, there is an inconsistency. When inconsistency exists, Companies Act do not apply to them, their own act will apply. That's why our deposits chapter does not apply to these 4 companies. One by one, everyone answer. Understood the point clearly or not? So tomorrow in the examination, if you find any question on NBFC accepting, housing finance company accepting, what you have to write? Deposits chapter does not apply. Everyone reply first. I will go as per your reply. You say yes sir, I will go to the next point. So what is the part of the revision that we are going to start? Deposits. In deposits, what we have started first? Applicability of deposits chapter. Deposits chapter do not apply for 4 people. Number 1, banking company, it will not apply. NBFC, it will not apply. Housing finance, it will not apply. Other companies notified by CG also, it will not apply. Why it will not apply? Because for them a separate law itself is there. Okay, next one. Deposit provisions only regulate acceptance of deposits by non-banking and non-financial companies. Means what? Manufacturing companies, trading companies, service sector. These people accepting deposits, okay, this chapter will get applied, or else this chapter do not apply. Everybody understood? Yeah. Next. Deposit under section 2 clause 31 and rule 2(1)(c). Deposit includes, when I say includes, not only that, so many things will get entered into that, but it includes this. So deposit includes receipt of money by company as a deposit or loan or in any form, but does not include the following. So any receipt of money made by the company is a deposit. Sir, any receipt of money means I received debentures money, not deposit. That's why those are all in the exclusions. Now we are going to see exclusions, so please listen carefully. Okay, see. Just a minute here. Okay, see here. Okay. This is also a simpler way of understanding what is not a deposit. What is not a deposit? What is not a deposit? This chart is a more simpler than those charts. Okay, sir. Okay, listen first. What is a deposit? Deposit includes any amount received by the company, okay, in form of deposit or loan or any other amount, but does not include such amounts received by the company as prescribed in the rules. Done. Next one. Now let us try to understand. What is not a deposit. One by one I will explain. Listen carefully. Money received from government and related receipts. Any amount received from central government, state government, local authority, statutory authority. Never it will be called as a deposit. Remember everyone, government related receipts will never be called as a deposit. Next one, receipts from a foreign source. When I say foreign source, it can be foreign government, international bank, multilateral financial institution, foreign collaboration, or foreign body corporates, foreign citizens, or PROA under FEMA. In simple, exam question came, money received from any foreign citizens, foreign company, foreign organization, foreign banks, international banks, blindly write down, that will never be regarded as a deposit. So two things, government receipt, foreign receipts, never be called as a deposit. Next, receipts from banks and financial institutions. Why? Common sense na? For bank, if bank accept a deposit, I repeat, if the bank accept the deposit, okay, it will not apply, law will not apply. Just now we read na, this act does not apply, this chapter does not apply if bank accept a deposit. If bank gives the loans and we take money, then also their own law will apply for them or not. Therefore, any receipts from the banks, banking company, SBI, PFI, cooperative bank, scheduled bank, regional financial institution, insurance companies. In simple, money received from government, money received from foreign source, money received from banks and financial institutions never be regarded as a deposit, because Government is regulating it directly. Foreign laws of FEMA is applying. Number 3, if you receive money from any bank or financial institution, India already finance laws are there. Insurance company insurance law is there. Housing finance law is there. Banks ki banking law is there. Their own law is governing, not the Companies Act. Next one, receipts as short-term securities. Sir, I don't take loan from bank, sir. I will take money from the public only in the name of 14-day money, 30-day money, 182 days money, 91 days money. Short term I will borrow. Commercial paper, intercompany deposits, those are governed exclusively by SEBI guidelines, not by Companies Act. Therefore, commercial paper issue, intercompany deposits are not governed by Companies Act, they are governed by SEBI. That's why this is also not called as a deposit. First of all, what are we completed? Everyone do the revision. Number 1, money received from the government, money received from the foreign source, money received from the banks and financial institution, money received in the form of short-term securities. None of these will be regarded as a deposit. First of all, everyone put 1 yes. Everyone understood here clearly or not? Very good. Next issue. Sir, listen, I can tell damn sure that no other chart in India has produced deposits definition in such a easier way. You check anywhere. I spent hours together to prepare the charts. So please listen carefully. I broken each and every point into small parts and pieces, which will be easier. This also, if you don't read now, mistake is completely on your side. Please read properly. Receipts in the form of application money. Receipts in the form of what money? Application money. Company accepted application money. Sir, application money is a deposit. Application money is a share capital. Application money will become share capital if allotment is completed. Application money received, allotment not made, you have to refund. If you do not refund within 60 days, then it will become a deposit. Let's read. Company accepted application money. Allotment is pending. Allotment is done within 60 days from the date of receipt of application money. Okay, listen carefully again. Company accepted application money. Allotment is pending. Allotment is done within 60 days from the date of receipt. Exception: if allotment is not done within 60 days, allotment is not done within 60 days, then from the expiry of 60 days within 15 days, company shall refund application money. If not, from the expiry of 60 days, it shall be treated as a deposit. Everybody understood the concept clearly or not? Everyone, focus please, fast. Understood? If you are yes to this, we'll go into the next one. Done. Next one, receipts from directors. Receipts from directors and related parties. What is this concept? If you receive anything from the directors or related parties to the directors. Okay, see, let us see this. Amount received from a director. Amount received from a relative of a director. Relative of director of which company? Private company. So amount received from director of a company. Sir, when I say director of a company, it is both a public company and a private company. And amount received from relative of director of a private company, these are not treated as a deposit. From this, what you have to understand? See, listen carefully. Exam they can ask a question. Amount received by the company from its own director of a public company, not a deposit. Amount received by the company from the director of a private company. There is a private company, has a director. From the director it received money, not a problem. It is not a deposit, because we are reading which is not a deposit. In that, these two are not a deposit. Amount received from relative of director of a private company. From this, what you have to understand? If amount is received by a public company, not from its director, from his relative, then it will be treated as a deposit. It will be treated. Only private companies ke exemption was given. Means what? A relative of director of a public company, if we give, it is a deposit. No exclusion. That will become a deposit. Okay. So amount received from relative of director of a private company. Amount received from relative of director of private company. Okay. Next. But there is an exception again. There is an additional condition we have to read. Director of a company gave loan to company, or amount is received from him. It is a deposit. Okay, it is not a deposit. When it is not a deposit, this relative of a private company or the director of a public or private company have to give a declaration. Have to give what? Declaration, not oral, written declaration they have to give that the amount given by them, okay, is from their own sources of money, but they did not borrow. Means director borrowed from bank and giving to company, not allowed. Allowed or not allowed? Not allowed. So his own sources of money, through that he should give. Then only this exception will get attracted. Everybody answer understood the point up to here? Sir, if you stay consistently in live, session will be useful. I'm telling very clearly. Okay, on face. If you come, go, okay, it will not be sufficient. You are having exams. Okay, be serious about what we are doing now. Okay, because there is no point of me coming now. Why? But these 4 chapter students are leaving. They are asking at least 20 marks in every attempt. People are leaving. They are writing only for 80. They are not getting even 40. That is the problem. Let's focus on what is the problem and let's focus on the remedy properly. Let's not behave like a fool, coming and going out. So please have seriousness. Your exam, your life, your career, your parents, your family, they should be happy. Please show some seriousness. So point number 2, what you have to understand, amounts if received, in the question they will give that director has given the loan. Check whether it is a public or private. Any company exempted. When that director must have given a written declaration that amount given to the company is his own source of income, but not borrowed from someone else. Okay, listen. Like that, they can give a question now. There is a company called as X Limited accepting deposits from relative of a director. There is a company called as X Limited accepting deposits from relative of director. Depositor, not a depositor, deposit only. Sir, relative na, as a private company ke exempted, not for public company. Hopefully everyone understood this point also, right? That. Next, receipts from issue of debentures. Sir, debentures will become depositor. Yes, debentures are treated as deposit in one case. In one case. Do you know when? If they are unsecured. If they are unsecured. If the debentures are unsecured debentures, I will not treat them as debentures. I will treat them as deposits only. Everyone understood the point? Let us see. They are secured debentures. They are secured debentures. Sir, you said unsecured. Listen, yeah, let me complete. They are secured debentures or convertible debentures with compulsory conversion in 10 years. Compulsory conversion in 10 years. They are secured debentures. They are convertible within or convertible, not secured, but convertible into equity shares in 10 years. Therefore, in these 2 cases, debentures are not deposits. Exception. Listed debentures through non-convertible or unsecured are not treated as deposits. Are not treated as deposits. Means, even though they are unsecured, if it is listed, again it is not a deposit. So, what debentures are not deposits? Number 1, secured debentures are not deposits. Convertible debentures are not deposits. Listed debentures, whether convertible or unsecured, even then it's not a deposit. But secured debentures beyond security value treated as a deposit. Treated as a deposit. Sir, I did not understand. See, I issued secured debentures worth 100 crore. Asset security is 90 crore. 90 crore means loan taken from public is 100 crore. Security amount is 90 crore. How much amount of your loan, how much amount of debentures money taken from public is not having security? 10 crore. This is secured part, unsecured part, unsecured part. This part is treated as a deposit. That's what he wanted to tell. Like these questions will come. If you don't prepare properly, jump. Over. 3 marks or 4 marks are gone. Understood the point clearly? Everyone? One yes. Understood. So be careful. When you are reading the concept, be extremely careful what they are giving. Okay, I will tell again. Someone is asking. Debenture is not a deposit. Debenture is not a deposit. When debenture is not a deposit, if it is secured, they are not deposit. If it is convertible within 10 years, not a deposit. Sir, it is unsecured, sir. It is non-convertible, sir. Then also it is not a deposit if it is listed. If it is listed. Sir, mine is not listed, sir. Mine is not listed. Mine is not secured. Mine is not convertible, sir. Then it's a deposit. Though you issue as a debenture, I will call it as a deposit only. Everybody understood the concept clearly? Now did you understand after this explanation given? Everyone? Yeah. Next. Receipts from employees. Okay. Any amount received from employee. First, listen to the conditions first. Amount should be received from employee as a security deposit. Means employee joined. I don't know when he will leave. Therefore, I said that give some money to me first in order to give you an employment. Sir, how much? Not exceeding his annual salary. There is a contract to give like that. It is not interest bearing deposit. If all these conditions are satisfied, then that amount will not be treated as a deposit. So how many conditions? He should be employee, given a security deposit, and it should not exceed his annual salary, and for that it should not take any interest, and taking such kind of advance should be there in the contract of our employment, not illegally, not informally. There should be a contract. In that contract, the term and condition should be there. If an employee wanted to join, he should first deposit 1 year salary amount as a security deposit, then he has to join. Like that you have to first give, then only this will be possible. Okay, so when amount received from employee is not a deposit, number 1, he should be employee. Number 2, given money as a security deposit. Number 3, amount should not exceed his annual salary. Number 4, under a contract of employment. Number 5, it should not give any interest. Means what? You will give security deposit to company will pay you interest. What is this? It is indirectly company is putting the name called as security deposit and taking, but literally it's paying interest, means that will be treated as a deposit. So if it is not received from employee, it is a deposit. If it is received from employee but not as a security deposit, it is a deposit. It is exceeding annual salary, amount exceeding that will become a deposit. There is no contract for that, just informally they are asking, then it will become deposit. Every condition is satisfied but they are paying interest, then also it will be called as a deposit. When all 5 conditions are satisfied, how it is not a deposit? If any one condition is not satisfied, in all these cases it will also become a deposit. Did you all understand what I said now? Everybody. Everybody understood? Yeah. Next issue. Receipt as a trustee. Okay. Any amount received and kept in trust. See, amount kept by trust will never be called as a deposit. Next. Here, this is not the time to learn things. This is the time to revise things. Receipts in ordinary course of business. Sir, what is ordinary course of business? Ordinary course of business, so we will pay advances, right? Advance towards supply of goods. Or advance towards immovable property. See, I said, I want 1 lakh units. He said, sir, pay advance of 1 crore, we will send the remaining. Then I paid advance. That advance is a deposit for that company. No, it is an advance received towards supply of goods. Second one, I wanted to purchase a building. Worth is 5 crore. Okay, landlord said that you pay 1 crore as advance, sir. Remaining 4 crore you can pay at any time. That 1 crore I paid to that landlord, the company, that will not become deposit to them, because It is not a deposit. We are reading what is not a deposit. Advance towards immovable property. Next one. Security deposit towards performance of a contract. Security deposit towards the performance of a contract. I have to do something. Whether I will do or not is a doubt. Therefore, see, you asked me, sir, you perform this service. You perform this service. Example, you have a very big bungalow. You have a very big bungalow. You came to me. I'm an interior decoration company. This is an exam question. Listen carefully. There is an interior decoration company called as X Limited. It will do all interior and exterior decoration, painting, all these things they will do, wallpaper, everything. Okay. X Limited ki one person came. Okay. He said, please put all wallpapers throughout my interior, and exterior you need to paint a emulsion paint. That's a service. I will give you paint everything. You just do the labor work. Now it is a service given by the person. Clear? You will tell, do everything. I will close all my works and I will come to you. Later you will tell that, sorry, we are not going to paint my walls today, means my work will be damaged. Na? That's why whether you will really honor the performance or not, I don't know. That's why I said, sir, first pay some amount as an advance. Then we will do performance of the contract on that date. Now the advance received by that interior decoration company X Limited for painting all these things will not be treated as deposit because it is for the performance of a contract. Next one. Same, advance for long-term project for supply of capital goods. And last one, advance for future services. Advance for future services. The clarity I will tell you, what do you mean by advance for future services? Whenever you go to Bajaj Electronics, okay, whenever you go to Bajaj Electronics or Apple showroom, you buy any product, they will immediately tell that, sir, there is a warranty card, extra warranty you can pay. We will give you 2-year extra warranty, 3-year extra warranty. Like that they will tell. Reliance Digital, Bajaj Electronics, Vijay Sales, Apple stores, all these people, what they will collect, they will also collect an advance in the form of warranty. Warranty means what they will do, if any problem comes in the future, they will take care. That's called as advance for the future services. But condition, advances taken for future services can never be called as a deposit. Okay, when advance is collected for providing future services in the form of warranty, very important condition. Warranty period should not exceed time which is generally in practice or 5 years. Generally, you go to Bajaj Electronics, Vijay Sales or any kind of electronic company, warranty they will give generally for phones and other tablets, etc. These tabs, all these iPad, all these things are there. 3 years extra they will give. That is generally prevailing in the market as a practice. Sometimes they may extend up to 5. That's why they give 5 years. Generally in practice, sir, generally in practice is 2 years or 5 years. Should not exceed, they said. Should not exceed. So maximum that I will give is generally in practice or 5 years. Whichever is lower, you need to take. Okay. Next one. Now listen carefully. One important point. Advance towards supply of goods we read now. So you have to supply the goods. I take an advance. Company has taken advance. That is not a deposit. When it is an advance collected towards supply of goods. Okay. See, I said I will purchase 1,000 furniture. Tables are there. Okay. Tables. Benches are there. I said to manufacturer, I will buy 1,000 benches. Sir, he said, sir, each bench is 1,000, sir. So you have to pay 10 lakhs. You have to pay 10 lakhs. Okay. I will pay. He said that, no, sir. In the 10 lakh, 20% means 2 lakh. You have to pay now itself as an advance. I paid 2 lakh rupees to X Limited. X Limited received the 2 lakh advance. Received towards what? Received towards supply of goods. So that 2 lakhs is not a deposit for them. Okay. Now tell me, when it will become a deposit, if after 1 month or 1.5 months, when all the 1,000 benches are supplied, again I have to pay 1 lakh, 10 lakhs. I have to pay only 8 lakhs. I have to pay only 8 lakhs. Means 10 lakhs. This 2 lakhs is appropriated. Balance 8 lakhs only I should pay. If you are forced to pay entire 10 lakhs again, and then he is refunding back the 2 lakh, the 2 lakh for that 1.5 month period will become a deposit. So advance is appropriated against the goods. Such appropriation shall be made within 365 days. If there is any court case on supply of goods is going on, then extension will be given as per the court rule. Up to here, we completed substantial part of deposit definition. I want every one of you to reply, understood the point clearly or not? Are you all confident up to here, everyone? Very good. Very good, everyone. See, concentrate. Concentrate in the same way. We will complete this. Next, see, almost definition is completed. Next one. Amount received from promoters. Amount received from promoters. Any amount received from the promoters or relatives. From the promoters or relatives of promoter. In the form of unsecured loan. In the form of unsecured loan. As a condition imposed by the bank or financial institution against giving a loan. And the term of such unsecured loan is not more than term of bank loan. I will explain a simple way. Listen carefully. Fastly I will tell, one time only I will tell. I will not repeat even second time. Listen. There is a promoter who started a company. Okay. That person gave unsecured loan to company. Unsecured loan to company. Loan, unsecured loan. Promoter gave share capital. Along with that, he also gave unsecured loan to company. That will be treated as a deposit or not a deposit? That is not treated as a deposit. When it is not treated as a deposit, that loan, unsecured loan, is given by promoter as a condition kept by the bank or financial institution giving a loan to the company. Sir, I did not understand, sir. Simple logical I will tell. Exam, if question comes, you should promise me that you will not do a mistake. Listen careful, I will tell the logic. There is a bank. You went to a bank and asked for a loan. Promoter asked the loan. Bank, give me a loan. Bank said that, who are you? He said, sir, I am a promoter of that company. Okay. How much you invested as a share capital? Sir, 1 lakh. Okay. How much bank loan you want? 20 lakh. And a bank is a fool here. You will give 1 lakh out of your pocket and don't take risk. But you will ask the bank to give 20 lakh rupees and a 1:20 ratio. Do you think that I am a fool? Therefore, bank said that, is your company a successful company? No, sir. We started just 10 days back. How can I know successful or unsuccessful? Oh, will you believe in your company? Promoter said, yes, sir. I am a promoter of this company. I promoted that. Yes, sir. We will be definitely successful. Serious, sir? Very serious, sir. Pakka na? Pakka, sir. I am a genius of a guy, sir. How much loan you want? 20 lakh. You give 10 lakh. Sir, I should give 10 lakh. You give 10 lakh. I will give 20. You give 10 lakh first. That should be unsecured again. You should take risk. If you are risking and giving unsecured loan to your company, seeing you and believing you, seeing your confidence on your company, I will disburse the loan to you. Are you understanding the point or not? Okay. He said, yes, sir. I believe in my company. I will give. Promoter gave, okay, loan to company for 12 years, unsecured loan. Which loan? Unsecured loan. How much? 10 lakh. Bank, seeing him, has given a loan of 10 years to the company, 20 lakh. Okay. This anyway will not become deposit because the money received from the bank is not a deposit. Doubt is not on this. Doubt is on the first one. Will this be called as a deposit? For the first 10 years, it is not a deposit. Last 2 years, it is called as a deposit because loan term is only 10 years. Remaining 2 years, it is an unsecured loan given by you to the company. For the 2 years, it will be treated as a deposit. That's what the discussion he is going to make here. Everybody, answer understood? Everyone understood the full concept clearly? Hope you will not commit any mistakes. Okay. Next. Deposits accepted by Nidhi company, not a deposit straight away because it is governed by Nidhi rules. Next. Amount accepted under collective investment scheme. Amount accepted under collective investment scheme. SEBI collective investment schemes are there under that. Next. Amount received under any alternate investment scheme. That is also not a deposit. Just remember those words. Collective investment scheme, alternate investment schemes, not a deposit. Very, very important for exam. Amount received by startup. They will ask in exam, mark it extremely important. Okay. Deposits accepted by startups. Amount is received by startup from a person in a single tranche, and one single shot like they receive. Amount is 25 lakh or more in the form of convertible loans repayable in 10 years. Either it should be convertible note, commercial paper type, or it's a debenture, or it's a money taken as a commercial note, which is convertible into share. When it is convertible into share, how can you call as a deposit? Or repayable within 10 years. Repayable within 10 years. If all these conditions are satisfied, then amount received by startups is not treated as a deposit. So when the amount received from the startups is not a deposit, received by startups in a single tranche from one person, amount is 25 lakhs or more, it should be taken in the form of convertible note or normal note only, normal amount only you receive, but repayable within a period of 10 years. Then I will not call it as a deposit. With this, we completed the most litigant, biggest area in this chapter. What is not a deposit is completed. Exactly, we have taken half an hour to complete the most important concept in this chapter, which 99 out of 100 students will miss it. That one student will be you. Yes. So, you ask any normal person, go and ask them. Amount received from promoters, tell whether it is not a deposit or what it is a deposit or not a deposit. Nothing will be there. No conceptual clarity, nothing. When everyone is leaving a concept, who reads that concept and become pakka, that fellow will become the leader. So please, you become the leader of that subject. Okay. So welcome. You also should become a very big teacher. So teach in a proper way, not to misguide the students, guide them in a proper way, guide them in impartial way. So this is the logic behind what is a deposit and what is not a deposit. First of all, everyone in the class should reply me, yes sir, understood or not. I'm waiting for your answer. All the live students, please, it's a request from my side. Put a yes such that I will get confidence that you understood. I will move on to the next one. Now, next question for you. You should honestly tell this answer. Yeah, honestly, you should tell. Okay. Do you think that you can read all these things in 30 minutes and complete? With this level of confidence, do you think that you can complete? Okay, you can complete all this in 30 minutes? Honestly, you tell. In 30 minutes, can you complete all these things? Yeah, that's the point here. Why I selected these is, okay, so we can't read like that. Always, that's why a big clap to all the teachers here, whoever taught you, because without a teacher, our life is always a dark. It's a great thing to have a good teacher because not misguiding, okay, properly impartial. If someone is telling that, you should really clap for them, you should really applaud them. They are doing a lot of favor to you. Okay. So the main point that we have to complete is, okay, the main point that we have to complete is, we have to read it in a proper way, understand, go to exam confidently, you will write. Okay. See, deposits chapter may come in exam, may not come in exam. But once this 3 hours our session is completed, how much confidence will build in within you? I completed deposits, I completed charges, I completed incorporation. Means how much confidence, whether it may come or not, that tension of those 3 chapters or 4 chapters will not be there. Clear or not? Okay. Let us start with the next one. Deposits rules. What is this? Deposits rules. I simplified this. You don't re-simplify the same. Okay. For the exams purposes, pakka exam oriented, I made this particular notes. Okay. See. company is prohibited to accept deposits from public except in the manner providing section 76 read with rules. Means what? A company cannot accept deposits from public. No, sir, I wanted to accept. Then accept as per the provisions of section 76. Accept as per the provisions of section 76. Okay. So then what is 73? Members deposit is 73. Public deposit is 76. Both are 80% same. Okay. Let's start. Okay. No delay. Let us start with all these. Then we will see acceptance of deposits from public, then punishment, then comparative differences. That's all. Chapter will be over. Main difficulty in this chapter is what is not a deposit here. That we completed. I am not having tension now. I am free. Let's start. Prohibition of acceptance of deposits from public. Company cannot accept deposits from public unless you comply with the provisions of section number 76. Next. Point number 2. Conditions for acceptance of deposits. Hey, I'm talking to you. Listen carefully. 1, 2, 3, 4, 5, 6, 7. 1, 2, 3, 4, 5, 6, 7. 7 points are there. Fata, 7 points. You have to remember, never forget, at least for next 1.5 days. Okay. Point number 1. It can be a public or it can be either a public or a private company. It can be either a public or private company. We are reading with section 73 first. So 73 la you are accepting deposits from members. Means you can be which company? Either public or private, because both have members now. So it can be a public company or it can be a private company. Next, condition number 2. Obtain the approval of shareholders by passing ordinary resolution. But SR in some cases. At a general meeting. So obtain the approval of shareholders by passing ordinary resolution in general meeting. In some cases, shareholders by passing special resolution in general meeting. Sir, when ordinary, when special, that we will read later. Next, issue a circular containing the details of 3 things: financial position, credit rating, number of depositors existing as of now, and amount due. Means if company have accepted any deposits in the past, still unpaid, how many people are there, how much money is outstanding, you should give. Depending on that, remaining people will come to invest. So you are accepting deposits from whom? Members. Which section? 73. What is there? It can be a public or a private company. Obtain the approval of shareholders by passing ordinary resolution in general meeting. Sometimes special resolution. What is the sometime? We will see later. Then you have to issue a circular. What do you mean by circular? Internally within the members, if you issue something, a circular. Okay. What should be there in that circular? Financial position of a company, credit rating you obtained, and number of depositors existing on that day, and amount due. And what amount due? Okay. Next. File circular with ROC. File the circular with whom? With ROC. Within 30 days. Very important. Don't commit mistakes. Prior to the issue of circular, not after issuing. Circular before you issue, 30 days before you should issue to ROC. In this 30 days, if there are any mistakes, now ROC will get a chance to stop you from issuing the circular to other members. So therefore, you wanted to issue circular to members today, na? Yes, sir. 30 days from today, go back. By that time, you should have issued to ROC first. Next. Very last attempt, this question only came here. Yeah. E point. What is this? Deposit repayment reserve account. Loudly. Deposit repayment reserve account. What is this deposit repayment reserve account? See, when we are in a traffic, 3 signals are there: green, amber, orange, red. Okay, 3 lights are there. Red resembles to stop, green resembles to drive, amber, that orange color light will come now, that always represent, okay, get started, get ready. Okay, same. Deposit repayment reserve means what? In next 1 year time, okay, for example, March 31st 2026, by that time, are there any deposits maturing in your company? Yes, sir. Then by 30th of April of 2025, by means what? Even before also you can do. Maximum date is 30th April of 2025. 20% of the value of deposit, you should keep it in a scheduled bank in a separate account called as a escrow account. You should keep there and get ready to make the payment after 1 year. Deposit on or before 30th April, a sum not less than 20% of deposit maturing on 31st March of following year in deposit repayment reserve account as a separate account with a scheduled bank. Next, if the company has committed any default with respect to any deposits already accepted, it cannot accept money in the form of deposits for 5 years from the date of making good the default. Means if a company has accepted deposits, if a company has accepted deposits in the past, okay, and they made default in making the payment to them, okay, and finally they paid, from the date on which you made the payment completely, from that date for 5 years you cannot accept any kind of deposit, any kind of deposit. If you are accepting unsecured deposit, if you are accepting unsecured deposit, circular like clearly mention that it is unsecured, that it is unsecured. First of all, everyone tell me 7 points are there, okay. Those 7 points you should prepare and keep in mind, never you should forget. Reason I will tell you, these all 7 conditions apply also for public deposit section 76. This is all contained in section 73 subsection 2. 76 section of what they will tell, 73 subsection 2 is as good as applicable. Means what? If a question comes in examination on 76, you should first write all these things and then write extra points on 76. Understood? Let us say company can be either a public company or a private company, but 76 is only public company. Shareholders, by passing an ordinary resolution, general meeting, some cases special resolution, issue a circular containing the details of financial position of the company, credit rating obtained, amount of number of depositors and amount balance outstanding. Number 4, file the circular with ROC 30 days prior to the issue of circular. Next one, deposit on or before 30th day of April of the year, okay, April of the year, an amount not less than 20% of the deposits maturing on 31st day of the following 31st March of the following year in a separate account with a scheduled bank. Next one, if any default is there in repayment of deposits or interest on deposits on any of the previous deposits and made good later from the date on which it is made good, from there 5 years you cannot accept the deposits. Next, if the deposits are unsecured deposits, circular like clearly in bold quotations you should mention it is unsecured. These are the 7 points here. Okay. Now everybody in the live should reply. Did you all understand the point clearly? Everyone, did you all understand the point clearly? Deposits point. Everyone. Yeah. Clear. Next issue. Next issue. So 2 minutes time I will give to everyone. Please read all the 7 conditions. This is your last time before going to exam. Like that you read. Read all the 7 points. Everyone, if you are clear to the concept, we will go into the next one. right? Yeah. Next one. Acceptance of deposits from public. Acceptance of deposits from public. Applicability. Public company only, not applicable to private company. Clarity, na? Because private company definition of what we read, private company means a company which is not a, private company means a company which is having minimum paid up share capital and by its articles, it will restrict transfer of shares, limit the total number of members to 200 and prohibit the public subscription of securities from the public. So, private company cannot accept deposits from public. So, public company only can do this. Conditions of applicability. It should be very, very important. Don't do mistakes in this section. It should be a public company. Condition 1. Net worth should be 100 crore or more, or turnover 500 crore or more. Means net worth should be either 100 crore or more, or turnover should be 500 crore or more. Any one of the conditions you should satisfy. From this, what you have to understand, examiner they will ask a question. There is a public company wanted to accept a deposit. Which section will apply? Section number 76. 100% wrong answer. Not public company. Deposit section, what you have to understand, companies are divided into two categories. Okay, public or private. Public, private, public. Okay, private, public are two types. Private company ki section 76 anyway do not apply. Public company it will apply two parts again. Part 1, it is a public company whose criteria means is not met. Criteria not met means net worth 100 crore or more or turnover 500 crore. That not satisfied. My net worth is only 70 crore. My turnover is only 300 crore. I am not falling into the criteria requirement. Then I will not be eligible. Even though I am a public company. So even in this case, section 76 do not apply. Next, I met the criteria. Requirement. Tell me, if I meet the requirement criteria, can I accept deposits under section 76 or not? Now 76 will apply or not? Everyone. Now 76 will apply or not? Everyone. In this case, 76 will apply or not? Everyone tell me. Company is a public company. Meeting the criteria, then it will apply, then 76 section will apply or not? Even in this case, it is no if it is banking company or finance company, housing finance company or something like that, it does not apply again. If it is not any of those, being a public company satisfying the criteria requirement, then the answer is yes. Like this, you need to write the questions in exam. These all things should come in mind for you. When it will come into mind, if you mind what I am saying today, then it will come into your mind in the exam hall. Okay, next. So, conditions. Public company, net worth should be 100 crore or more or turnover should be 500 crore or more. Pass a resolution subject to 181C. They important. Just now I discussed which resolution we need to pass? Ordinary. But sometimes special resolution. What are the sometimes? If the existing borrowing together with the proposed borrowing, existing borrowing together with proposed borrowing, okay, proposed borrowing, in this borrowing what will come? Public deposits will come, exceeds paid up share capital, free reserves and security premium. If existing borrowing along with the deposits, proposed borrowing along with the deposits, if it exceeds paid up share capital, free reserves and securities premium. Sir, one thing is very clear. Deposit is a borrowing. In this existing borrowing, already accepted deposits will come. In this proposed borrowing, now you are going to accept that will also will come. Public deposit you are going to accept. So, existing borrowing with the deposits, existing borrowing loans will come, commercial papers will come, all kinds of loans. Plus proposed borrowing, public deposit form. If it exceeds, okay, paid up share capital, free reserves and securities premium. Do you know what do you mean paid up share capital, free reserves and securities premium? That's called as net worth. That's called as the net worth of the company. So, if the simply, I call this entire thing as equity. I call this entire thing as debt. Debt if it is going beyond equity, means debt equity ratio is going beyond 1:1, special resolution is required. That's the meaning. In all other cases, ordinary resolution is required. Everybody understood the concept clearly now? What is this ordinary and special resolution nonsense? Understood? Yeah. From this, what you have to understand, one point is very clear that when special resolution is required, if the existing borrowing with the deposits, proposed borrowing with the deposits exceeds paid up share capital free reserves and securities premium, then SR, or else no SR, only ordinary resolution. Next. Next. After that. So first one completed, conditions over. Other conditions comply with the requirements of 73 subsection 2, means the 7 conditions. How many? 7 conditions. Comply with the rules. Okay. Credit rating conditions. Obtain credit rating from a recognized credit rating agency. Obtain credit rating from recognized credit rating agency. CRISIL, like these companies are there, na? From them obtain your credit rating. They will see your financials and give you a rank. Obtain. Rating must be informed to public before accepting. Sir, only before. After, if my rating fall, then what will happen? That's why rating shall be obtained every year during the tenure of the deposit and then published to the members. Next. Where company accepts secure deposits, it shall within 30 days shall register the charge. Anyway, in the charge chapter, we will see that. Up to here, everyone understood the point clearly or not? Everybody, please answer. Did you understand 76 section properly? Yeah. Accepting deposits from public. Are you all confident? I want your answer. I want your answer, everyone. Yeah. Next. So this is a punishment section. Punishment sections I am not going to discuss. Just read and remember the punishment section. Let's not waste time. Next, we are coming into the another dangerous area of this chapter. 10 minutes we will spend on this. We will go into the charges chapter. Okay. What is this area? This is 73 read with 76. 73 read with 76. Comparison. Okay. No other class in YouTube you can find where there is a comparative differences between 73 and first deposit chapter not dealt. This much detailed deposit chapter not dealt. Even if dealt, these two sections comparison no one is doing. So please listen carefully. For the effort that I have put inside, you should show some respect in listening to this entirely in a proper way. Okay. I am making it full screen. I am making it what? Full screen. See now. First, concentration is the key. The greatest respect that you can show on me is not telling any thanks, etc. Listening to this in a proper way. Okay? Listen to this in a proper way. First 2 minutes time I will give you. See the chart properly. After that, we will start discussing. Everyone completed? Shall we begin? I gave you 2 minutes time for you to read. Hopefully you read this. Shall we continue? Yeah. See, let us see now. Content. Acceptance of deposits from members. Acceptance of deposits from public not being members. Who can accept deposit? Both public and private. Here, only public. Only public. Issuance of circular. Circular is mandatory. It shall be in form DPT 1. Circular shall be then attached to certificate of statutory auditor that there is no default in deposit. Means every circular should be attached with the certificate of the stat auditor that no default is existed in deposit. Same as section 73. Same point you have to write also in 76 question in exam. Validity period of circular. 6 months from the close of financial year or AGM date if held or last date if AGM is not held, whichever is earlier. Means prepare a circular today. When you can issue not for life, next 6 months it will be valid. Within 6 months if AGM is held, till that date it will be valid. That's it. AGM if held, okay. If not held, last date will be there in 96 law. That day ki circular will expire. Means the circular you print will not have infinite validity period. 6 months validity period only will be there technically. 6 months validity period or AGM date, whichever is earlier. Simple way. Very important tenure of deposits. Last attempt it came. Before last. Minimum 6 months minimum period you should accept. Maximum can't go beyond 36 months. Don't write 3 years. Months only they will do. No demand deposits. You cannot accept demand deposits. Sir, what do you mean by that? Demand deposit means you will give. Whenever you want, the company has to give you back. Those kind of deposits we should not do. Why? Those kind of deposits can be accepted only by banks. You will open savings deposit in the bank. What is the savings deposit? Today, if you go and tell the bank, I wanted to close, they have to close. That means they have to give the money on your demand. That's why they are called as a demand deposit. Next, no exception to the maximum term. No exception to maximum term. Maximum term 36 can be extended. Any exception is there? No exception. But exception is there to minimum. Okay, minimum 6. Sometimes minimum can even be 3 months. When if the deposit amount you are accepting is not exceeding 10% of paid up share capital free uses and securities premium, means the deposit amount you are taking is as low as 10% of the entire net worth of the company, then no problem. 3 months also you can accept. Next, maximum amount of deposits. ED means existing outstanding. PD means proposed deposit. Maximum amount of deposits. How much I can accept? If you are accepting under 73 from the members, okay, existing deposits from proposed deposit, existing deposit and proposed deposit cannot exceed 100% of paid up share capital free reserves and securities premium. Cannot exceed 100% of paid up share capital free reserves and securities premium. So maximum how much only you can take in the form of deposit? Take existing deposit, take proposed deposit. The total should not exceed the net worth. Okay. Next, if you are a public company taking from the members, then 100% is not a public company, so much of capital will be their net worth. So deposit borrowing amount should not exceed 35% of paid up share capital free reserves and securities premium. In case of which company? Public company. Accepting deposits from whom? Members. That's why here also same provision will follow. Private company prohibited. Eligible public company from members 10%. From members 10%. Okay. So public company from members can take 10. From public it can take 25. Totally become again 35%. Same like this. Next, government company 10 to 25 not there. From anyone you can take. Overall should not cross 35%. Next, premature settlement. Premature settlement means I wanted to settle even before. Can I? Yes. Request should be from the depositor. Company should not give any choice. Company cannot voluntarily do. Interest will be reduced by 1%. Means, for example, I accept a deposit for 12 months. After 8 months, one deposit holder came and said, please give my money. I will give you. For 8 months, I have to pay interest. For 8 months, I have to pay interest. For example, we promised the 9% interest. I will pay only 8% because 1% is the penalty for premature termination. Everybody understood the point clearly or not? Everyone. Everyone reply. Understood the concept clearly? Yeah. So now, everyone, please answer. Yeah. Now we completed deposits chapter successfully. 1 hour we completed a very big area called as deposits. Okay. Some extra rules are also there that I will share it in my Telegram group. Just read them. Those don't require great analysis. Just read and leave. But this penalty, na, you must read exam. The question will come. General penalty. I have to remember penalty. That's all. Nothing to discuss. Okay. So someone is asking about validity period repetition. Just I will repeat for 1 minute. Circular you issue today. The issued circular, you can issue members. Till when it is valid? Within 6 months, you should complete. You should start the deposits issue. Okay. How much validity period is there for the circular? 6 month period. Okay. For example, I issued that in the month of June. June first I issued. June, July, August, September, October, November. Generally till November the circular is valid. Means on that circular you can accept deposits till November. But September like AGM came. That's it. Validity is gone. Okay. So June, July, August, September. 4 months only the validity period, not 6. So if you are issuing in the month of January, February, March, April, May, June. Okay. July, August, September. Like that you can't go till September because this came earlier. Na? By the month of June, it will be completed. Validity will be over. Now did you understand? Those who asked the question. Now did you understand? Yeah, that's it. So with this, we completed the entire deposits chapter. We are now going into the next very important left out area by the students, charges. Okay. See, next concept we are going to start is charge. Which concept here? Charge. Okay. See here. Definition of charge and types of charges. Okay. What is a charge? Charge is a security created on the assets for the loans taken. Whenever you take a loan, there is a doubt whether you will pay or not pay. For that, we will have a security to be taken. That security will be called as a charge. Let us see. Charge is an interest. Interest means not interest payment. Interest means concern, that interest. Interest or lien created on the property or assets or undertakings of a company, or both as a security and includes mortgage. Simply, if a question of charge is coming in exam, charge is an interest or lien created on the property, assets or undertakings of a company, both as a security and includes a mortgage. Simply to tell, any security taken, loan taken by a company from someone, for that security is kept. A security we call as a charge. For that you put the name lien, for that you put a name interest, for that you put the name mortgage. Security or not a security or security. That's it. It becomes a charge. Up to here, everyone understood the point clearly? Up to here, everyone understood the concept clearly? Can we go on to the next one? Sir, we completed deposits. We put lot of efforts and completed. If you really understood everything, okay, like the video and share it to your friends such that it will reach to the maximum people. The efforts we put will always be materialized when you like it and share it to people. It will reach more number of people. And 100% you can understand, my YouTube channel is not monetized. So this is a non-monetized channel. I will not get even a single rupee from that. But still, efforts will be reaching more number of students. Means I will be more happy. That's why. Okay. So point number 1 that I request everyone is, if you really like it, please like that and share it to your friends such that it will reach many people. Efforts will reach so many people in North also. Okay. That's the thing. Let us now start with registration of charges. Definition of a charge. Charge is an interest or a lien created on the assets of a company or undertakings, either in the name of a security or mortgage. Next, very, very important thing. This time in the attempt, you have to expect this question to come. What is a fixed charge? What is a floating charge? What is a fixed charge? What is a floating charge? Let us see. Fixed charge. Fixed charge is a charge on specific assets of the company, on such as permanent nature assets, land and building, plant and machinery, specific assets is called as fixed charge. Such a charge is created by mortgage or deposit of title deeds. Means there is a building kept as a security, building will be kept as security, yeah, documents will be kept as a security. Next, borrowing company is not permitted to sell such assets during the period of charge except with the consent of the charge holder, but it may use them. Example, building is there, I kept it as a security for a loan, okay, for 3 years loan. Now for 3 years, can I use the building? Yes. Can I sell the building? You can sell only with the consent of that other person. Without his consent, you cannot sell the building. Next, charge is vacated when borrowed money is repaid. Means when the charge will be cleared, when the borrowed money is cleared, then automatically charge also will be released. This is the concept of fixed charge. Okay, read it first. I am making it full screen. Please read it properly. Important chapter here. Please show some concentration. Your exam is there in 1.5 days. Charges chapter you are leaving. Okay. If you complete, let me know. We'll go into floating charge. Everyone, charges chapter came in the last attempt for 14 marks. Institute valuation report, clearly they have written that charges chapter student did not perform well. So there is every chance again this attempt minimum 10 marks can come from charges. Please don't take risk unnecessary. 3 months will be wasted because of your mistakes. Small mistakes can lead to a lot of damage. Again, don't put a point of after live I will listen to the video. That can never happen. If you cannot listen in live itself, then how can you listen after that? So concentrate. We will complete everything in live. Okay. Next one. What is the next one? Floating charge. Fixed charge means on specific assets. Okay, like plant and machinery, land and building, which are there physically. Okay. Next, floating charge. It will be floating, circulating. So fluctuating, changing. Raw material stock debtors. I say 1 crore worth of raw material is security. Which raw material? Whatever raw material is there in the godown, 1 crore is belonging to me as a security. Today's raw material will go out. Okay, again I will buy. On that newly bought one, I again have a security. So floating means the raw material can change, but on the raw material, 1 crore is always a security for me. Assets under the charge keep on changing as companies permitted to use them in the ordinary course of business. Buyer of such assets get good title and free of charge. Buyer of such asset will get good title and free of charge. So simply to tell what you have to understand, fixed charge, listen carefully here, please. Fixed charge building kept as a security. Building kept as a security. If you sell that building, security on that also will pass to the new buyer. That means whoever buys the building, whoever buy that particular building, that building, whatever he purchased, will be still in the security with the bank only. Free from charge will not happen. But floating charge is not like that. On raw material, I will put the charge. On raw material, I will put the charge. I will sell that raw material to someone. that person is no more responsible to the bank. That's why buyer of such assets get a good title and free of charge. Everyone understood all the 3 points in fixed charge and floating charge clearly? Yeah, I want your answer. Everyone understood the point clearly? Fixed charge and floating charge concept. Yeah. Next, crystallization of floating charge. What is this? Crystallization of floating charge. Sir, what do you mean crystallization? Conversion. When floating charge become fixed charge. What do you mean floating charge? Those are fluctuating in nature. Company can deal with the asset without permission of the charge holder, and the other person who buys that will get a good title free of charge. So they will change every day. Company can deal, company can sell the raw material also, even though it is in charge, because when they buy new raw material, on that again I will get the charge. But when floating charge becomes a fixed charge, important question for the exam, floating charge remains dormant, means inactive, until it is crystallized or fixed. Okay, so it will be floating charge only till it is crystallized. On crystallization, it is fixed and available for realization by lender. Floating charge gets crystallized in the following cases. Number 1, when creditor enforces security due to breach of terms and conditions of floating charge. Means what? You have taken loan, kept raw material as a charge. You are not paying the loan properly. What he will do? He will tell, stop selling that to outsiders, I will take and sell. Then floating charge became fixed charge. Simply, I can tell default. If you commit any default, floating charge will become fixed charge. Next, company ceases to continue the business. Company business say closed. That's it, closed. Company goes into liquidation. In these 3 cases, floating charge will turn into fixed charge. I am putting the chart before you for 2 minutes. Please read that properly. Become full clear on this particular concept. We will be going into the next aspects of charge chapter. Participate, sir, everyone. Dangerous chapter this will be. Sir, all the charts I will share it on Telegram. No problem. First concentrate on the screen. Complete it. Be focused on that. Read. Very important chart. So you read, I will, on background, I will give you idea behind this concept. Charge is always talking about a security. There are 2 types of charges, fixed charge or floating charge. Fixed charge will be created on specific assets which are fixed in nature, which won't circulate or fluctuate. Okay. So company cannot, the borrowing company is not allowed to sell that asset. It can only use that asset. If you want to sell, take the permission. If anyone purchase that asset, the security is still in the bank. He is purchasing asset which is subjected to charge. Over. Floating charge is always circulating in nature or fluctuating in nature, like raw material, stock, debtors, etc. Okay, they keep on changing every day. And most important thing is the buyer of such assets gets a good title and free of charge, even though he bought the asset subjected to charge, because it's a fluctuating one. Crystallization is very important question. Crystallization means conversion of floating charge into fixed charge. 3 cases la conversion happened. Default committed, company stops carrying on the business, or company went into winding up, liquidation. In that cases, fixed floating charge will get converted into fixed charge. Everybody, are you all confident up to here? Can I move on to the next one? Can I move on to the next one? Everyone understood up to here? You give a reply. We'll go into the next aspect. Yeah. Now, see here. Now what we are going to do is, now we are going to cover all the sections of this charge chapter. Okay. All the sections of this charge chapter. All important contents are there. Those important contents I will cover. I will not take your long time. Just half an hour from now, we will complete this entire charge chapter. Please listen carefully. Okay. See here. Duty to register the charge. Duty to register the charge. See, whenever charge is created, it is the duty of the company to register the charge. So the primary duty of registration of charge is in the hands of the company, Okay, see here. It is the duty of the company, creating the charge on property assets undertaking, tangible or intangible. So whose duty it is? It is the duty of the company creating the charge on property assets, etc., whether tangible or intangible, situated in India or outside India, to register the particulars of charge along with the copy of instrument signed by company and charge holder with ROC within 30 days of creation of charge with a fee. In simple language, if I have to tell, whose duty to register the charge? Company duty. So it is always the duty of the company to register the charge. Number 2, once the charge is created, within 30 days of date of creation of charge, you should file with ROC for registration of charges within 30 days in a particular form along with the copy of charge instrument signed by the company as well as the charge holder. So in simple, let us see. It is always the duty of a company which created charge. Students are committing mistake. Listen carefully. This section is not talking about creation of charge. I repeat, this section is not talking about creation of charge. This section is talking about filing the charge with ROC after its creation. This section is talking about registration of charge. Okay, this is not talking about creation of charge. The moment you create, within 30 days, you have to register that with the ROC. Okay. If charge was not registered within 30 days, company shall make an application to ROC for extension. For what? Extension. ROC is satisfied that company had a sufficient cause for not filing the charge within 30 days. It may allow registration to be made within 60 days of creation of charge. That is extended by another 30 days. So normally you have to file a charge within a period of 30 days. You did not do. Apply to ROC. ROC has to be satisfied that there is a reason for you to have a delay. Then he will extend it by another 30 days, totally making it 60 days. Sir, I could not register even then. Second chance, the final chance will be given. If the charge is not registered within the extended period, again make a application. Again 60 days chance will be given on ad valorem fees. This is a additional fee already fixed. This is ad valorem on daily basis. Daily 200 rupees means delay is by 100 days. Now 200 into 100, you have to pay the 20,000 rupees. That way. Ad valorem means a daily. Additional fees means a fixed fee. So let us understand. 3 situations can occur. How many? 3. Creating a charge. Within 30 days, you have to file with ROC paying a fee. Nothing is free. You have to pay the fee. 30 days I did not. Next another 30 days I will give. So totally within 60 days of creation of charge, you should file with fees and additional fees. Number 3. You did not file even then. Then what will happen? You have to pay fee plus additional fee plus ad valorem fee and file. But totally 30 days plus 30 days plus 60 days. 120 days of creation, you have to file it with ROC. This is the first point everyone has to understand. Next. Note. Particulars of charge shall be filed with ROC in form CHG1. CHG9 in case of debentures. Means you will file with ROC na? If it is other than debenture, CHG1. If it is debenture, CHG9. Remember, these both are important. Yesterday I made one video on penalties, forms, formats. See that video. I am not making any joke sake. I am doing all those for your benefit only. Since you won't read, they are giving an exam and losing marks. Na? I made a video also on that. Did you see that, anyone? Anyone did you see? Subject related videos are most important for you. So see that. I'm not doing any dance there. I'm not singing any songs there. In that video, I clearly mentioned what are the penalties applicable for your syllabus. I completed penalty discussion. Forms applicable for your exam. Sections requiring ordinary and special resolution, I made a video. 30 minutes I covered all these. Along with that, applicability criteria also I covered. Understood? Okay. Don't consume too much of unnecessary content on YouTube. Yeah. Don't see lot of motivational content. It will demotivate you. Read subject. You become perfect in what you are doing. Automatically remaining things will come in place. Okay. Listen carefully. Particulars of charge. Whenever you create any charge, file CHG1 with ROC if it is other than debentures. If it is debentures related security, CHG9. Next. Sir, I created charge, sir, but I wanted to modify, sir. Okay, that form I wanted to modify. What to do? Instrument creating or modifying charge, okay, which is to be filed with ROC, shall be verified by instrument relating to the property. Copy shall be verified by director or company secretary. Sir, that is not that important. Next, if the charge is registered, ROC will issue certificate of registration of charge in form CHG2 and certificate shall become conclusive evidence. Sir, I did not understand this. See, company will file with ROC, okay, certificate of creation, document of creation of charge or instrument of creation of charge in CHG1 or CHG9. ROC, if satisfied, will give to the company, okay, certificate of creation of registration of charge, okay, don't read kokoroko, okay, creation of charge in form CHG2. Understood the point clearly here? So CHG1 and 9 for company to ROC, CHG2 is for ROC to company. Everyone understood the point now? Everyone understood the point now? So we will file in CHG1 or 9. ROC will give us a certificate in 2. Sir, if you are clear, I will go into the next one. Okay. Next issue. This is only a procedural content here. Just read and leave. Main content, I told you what are the forms. Next. Consequences of non-registration of charge. Okay. What will happen if the charge is not registered? Charge becomes void and is not taken into account by liquidator or any creditor unless it is duly registered. I created charge but not registered it. Then if liquidation happened, that loan will be treated as unsecured loan only. See how dangerous of not registering it. If you do not register, that will be treated as a unsecured loan only. Even though security is created but not registered, if not registered, the charge will not be considered. At the time of winding up, creditor whose charge is not registered would be treated as unsecured creditor. That's what I told. Charge holder loses priority. Failure to register charge create a liability on company under 86. Okay. See, non-registration of charge does not prejudice obligation of company for repayment of money. That is, debt is valid and may be enforced through court, but security is only lost. Also, subsequent registration of charge cannot prejudice the rights acquired on the assets before such charge is registered. Sir, I did not understand this. Listen carefully. All these are exam points I have given here. See, important point. Charge when it is created, you should file it with ROC within 30 days in CHG1 or CHG9. You did not. Then what will happen? I will give a time of 30. You did not. After that, I gave 120 days, 60 days extra. You did not. Now this is an unregistered charge, a dangerous charge. Means what? You created charge but not registered. Okay. Means the loan giver thought that it is a secured loan. Since you did not register, it is still unsecured. In the meanwhile, company went into liquidation. Loan is valid. Security is invalid. That's what you wanted to tell. Loan becomes valid. You have to pay the loan. Debt is not affected. Security is lost. Everybody understood the point clearly now? Everyone understood the point clearly now? Everyone understood the point clearly? Very good. Next issue. Now we are going into 78, 79, 80. Next 84, 82. Next 83, 81 and 85. Next 87, 86. Okay. First we will come in a different order. First 86. Any punishment, anything contravention of this particular chapter. First, if company defaults in this chapter, company penalty 5 lakh. Company penalty 5 lakh. Officer in default 50,000. You have to remember. If any document filed with ROC is furnished fraudulently or unlawfully, then 447 fraud will get attracted. 86 over. 86 over. Okay. Next one. Register of charges. Register of charges. Sir, what is a register of charges? Register of charges means whenever you file a charge, your document should be kept in a register, not physical, electronic register. Now, two questions will come. 81 and 85, two sections are there. Why? One is a register maintained by company, another one register maintained by ROC. Sir, what is the difference, sir? See, my company will have my company register. ROC will have all the companies register in that state because ROC is for a state. So, register of charges kept by a company. Company shall keep register, okay, in form CHG 7 at its registered office. Register shall include particulars of registered charges, acquired property, and charge modification, everything. See, three things should be there in that register. Charges registered, charges modified, charges satisfied. Three things. Charges registered, creation. Charges modified, changes. Charges satisfied, repaid. Sorry. So, charges satisfied means repaid. So, company shall keep the register in form CHG 7 at the registered office. At the registered office. It should contain the particulars of charges created and registered, modified, satisfied. Next. Entries shall be made forthwith. Means the time will not be given. Immediately on creation, modification and satisfaction. Not only just having the entries in the book, it should be signed by director, company secretary or person authorized by the board. Any one of these three. Director, CS or any person authorized by the board of directors. That person should sign on that. That yes, whatever the document is, the same details they filled here. Okay. Next. So, tell me, company should maintain the charge register in form number CHG 7. What should be there inside? Charges created, charges modified, charges satisfied. Next, entry should be made immediately on creation, modification, satisfaction and authenticated by director, CS or any person authorized by board of directors. Very, very important point. See here. Register and instrument of charge shall be open for inspection during business hours. Okay. Means the register will be there, na? Register or documents, everything will be made available for inspection. Member or creditor without payment of fee, any other person on payment of a fee. So, member and creditors are within the company, na? Free. Remaining, they have to pay. Register shall be preserved permanently. Register should be permanently maintained till winding up. But stamp papers, all those other attached documents will be there, na? Those should be preserved for 8 years. MCQ, they will definitely ask a question. It will blast your face if you don't listen properly. I'm telling you very seriously about this. You are underestimating charges. They gave for 14. That's why last time failure in group 1 is because of law paper. Why? Wrong guidance, not understanding concept, leaving the concepts. Charges chapter unimportant, deposits unimportant. All are unimportant. Then what is important for you? So please have a proper mindset. Don't expect anything in exam. These are all expected questions. These are all guaranteed. Who is you or me or any other person to tell what is expected and what is unexpected? That's why I will always tell not expected questions. I will tell don't leave these questions. Because Kaushik Mukesh or any other person have even 0% knowledge on what will come in exam. Okay? Don't read guess questions and go to exam. When I say guess questions, I will always tell very, very clearly in the video also, these sections do not leave. That does not mean others you can leave. When you say expected these will come, a student only will read those. Later he will become the fool if those don't come. So please don't be under that impression. I am telling very clearly, may come, may not come. If you complete everything in the chapter now, then where is the concept of expected, unexpected? You are unexpected now. Anything you are able to write. So that you keep in mind always. That's the champion, or that's the spirit of a leader always. That's the spirit of number one always. Read everything. Target everything. Don't tell this is important, I is unimportant, I can leave this, I can carry this. I expected questions person will read and go to examination tomorrow. Day after, they don't come. What will happen at the end of the day? He will only suffer. Clear? Huh? At the time, Ghosh Mukesh will not come and tell, hey, I am very, very sorry, my questions did not come. That's why, even if I say expected, it means don't leave them. Remaining, you anyway will read. These, take care to read multiple times. That's the meaning. Okay, next. Such a register shall be, next one. Now, register maintained by company we completed. So to sum up everything, what is the meaning? Company shall keep the register of charges. Register of charges in form CHG 7. Second, it should include the details of creation, modification, satisfaction. Fourth, with entry, and director or CS or any other person authorized by the board has to authenticate. Over. Next, it shall be open for inspection. Member and creditor are free, others pay the fee. Next, register should be preserved permanently. Other instruments creating the charge should be maintained for the period of 8 years from the satisfaction date, not from creation date. Today you repaid the loan, from today another 8 years you should maintain the stamp papers, everything. Next, register kept by ROC. Here all registers will be there along with my register. ROC shall keep register containing the particulars of registered charges of every company on MCA portal. They will maintain. It will be open for inspection by any person on payment of fee. Sir, I am member. ROC key, it's not a one company, na? Everyone is an outsider only. So even if you are a member, so if you are a member of a company, go to the company and inspect free. If you come to MCA website, na, PDF will get downloaded only if you pay 10 rupees for each page. That's it. Everybody answer 81, 85 section. Understood clearly? I'll go on to the next one if you say yes. Everyone, if you say yes, I will continue. Yeah. Next one. Next one. 5 minutes each. Let's complete all this. Please see here. Application for registration of charge by charge holder. Listen, just now I told you, whenever charge is created, you have to register that within 30 days. Next 30 days. Next 60 days. Totally within 120 days. If you don't do, loan becomes unsecured. Now, who is the sufferer? Not the company. The person who gave the loan, also called as a charge holder. Therefore, if company do not file within 30 days, immediately a charge holder can come forward and file himself to the ROC saying that it has to register but it's not registering. So we are coming forward because we are the suffering parties. So if the charge is created but company fails to register with ROC within the original period of 30 days, charge holder may apply to ROC for registration. Okay. Immediately ROC will not do, okay, registration. Like that he should not do. Why you are coming? Actually company should come now. Why you are coming? Let me first ask company whether it is ready to charge filing or not. If it is not registering, then I will register yours. So on receipt of application from the charge holder, ROC shall give a notice to the company. Okay. Company should give a reply within 14 days. Within 14 days. If no objection is received from the company within 14 days, ROC will allow registration to be made by charge holder. ROC shall not allow registration by charge holder if company itself register the charge or company shows a sufficient cause why it should not be registered. Okay. So if company says, sir, I am going for extension, I will only file. If company say like that, very good. If company do not say like that, no reply came within 14 days, then I will go with registration to be done by charge holder. Okay. This is the point here. Actually, who should file? Company. Actually, who should pay the fee? Company. Since you are not doing, who is doing? Charge holder. By paying what? Fee. Fee or additional fee, as the case may be. If they pay any fee, they can get it reimbursed. Recover the fee from company only. Next. Acquisition of property subjected to charge and modification of charge. Sir, what is this, sir? I did not understand. See, there is a building. Already it is in the charge. Already it is in the charge with a bank. Okay. That building we are selling to some other person. That building we are selling to some other person. Or we are buying a property. We are buying a building which is already in the charge. Which is already in the charge. Those all together we are going to read here. See. First situation, company acquiring property subjected to charge. If property on which a charge is registered is sold with the permission of charge holder, company acquiring it shall get the charge registered under section 77. That is, earlier charge gets vacated, new charge is registered. Previously charge is in the name of A Limited. I am B Limited. I acquired now the names have to be changed. You have to again re-register the charge under section 77. Modification. If any changes are made in the transaction of loan, for example, I took loan from a bank, 1 crore, asset kept as a security, 1 crore. Later I change the terms and conditions. Interest payment is actually 12. I reduced it to 9 now with the discussion, negotiation with bank. Term generally is 14 years. I increased it to 20 years. Okay, either increase or decrease, something happened. Now it lead to modification in terms and conditions. Okay. So whenever there are modifications in terms and conditions, you should register that modifications also with ROC. ROC shall issue certificate of modification in CHG3. In what? CHG3. So you will apply. You will apply in same CHG1. Company will apply to ROC for creation or modification in CHG 1 or 9. ROC will give you certificate of modification of charge in form CHG3 to the company. If it is certification of creation of charge, CHG2. Here you have written CHG2. Modification will be given by ROC in CHG3. Next. Deemed notice of a charge. Listen. All the charge registers are kept on MCA website. Means if any outsider is purchasing asset from a company will not tell whether there is a security or not. Okay. No one will tell. Let the buyer beware. Doctrine of caveat emptor. Buyer should go to MCA website, check the asset, whether the asset is in security or not, and then he has to buy. Later, if he find that there is a security on that asset, he should not cry, because you should be aware when you are buying an asset. All charges registered with ROC are public documents, and any person can refer MCA website to find out the charge created on asset. If the charge is registered under section 77, any person acquiring such property is deemed to have notice of the charge. Any document filed with ROC for registration acts as a constructive notice. That's why doctrine of constructive notice will apply. Okay. We completed 78, 79, 80. Everyone in the live, please tell, did you understand or not? Everyone in the class, please reply, did you understand or not? Yeah. Take a minute time, read it. Complete it. Charge holder should go within that 120 days, or else another section will apply. That also I will discuss. Everyone in the class, did you understand this complete answer? Everyone, charges chapter, everyone understood clearly? Up to here. Everyone give a reply. Did you all understand the charges chapter up to here? Okay. Next, we are going to do revision of section number 82. Section number 82. Section number 82. First one, everyone tell me. Are you all with me? Everyone? When beginning what momentum you will start, till the end, you should bring the same momentum in your understanding and listening. That's the secret of success. Now, consistency is the secret. So maintain consistency in your listening. Okay. Once we complete these two areas, deposits 6 marks, charges 5 marks. At least 10 marks we covered now. After this, there are another 7 marks chapter and 5 marks chapter. 12 marks is still there. Okay. I will give a 15 minutes gap and then we will again begin. Let the time be taken. Yeah, no problem. We will complete 4 chapters now. After this, happily you can study the remaining chapters. I have given the plan completely. What you need to do. Okay. And moreover, the most important thing that everyone has to remember is day after tomorrow, when the law exam is completed, we will have a 10 minutes live. You will tell me how you have written the examination. That much confidently I am telling you. Beyond this, questions won't come. Confidently you go to exam. Okay, that confidence will come only if you read everything. Prepare everything, confidence will come. Expected questions, if you read, confidence will be gone. Reason is, still there are left out concepts. That confidence will never come. So, let's read. 82. 82. Company to report. Satisfaction of charge. Creation we understood. Modification we understood. Now we are going into satisfaction of a charge. Company shall give intimation of payment or satisfaction of charge in form CHG4 to ROC in 30 days. You paid the loan. Now, charge creation ki how registration is important. When loan is repaid, charge is satisfied. This also has to be registered. Same within 30 days. Okay. On receipt, ROC shall send a notice. Listen carefully now. Loan is not repaid. Company is sending to ROC, release the charge. Release the charge, vacate the charge. We paid. ROC will release the charge. But actually, loan is not repaid still. If it goes into liquidation, creditors will be in a great trouble or not. That's why ROC and Companies Act are not fools. Whenever companies send us charge satisfaction document, which document? Charge satisfaction document, immediately ROC will send a copy of that notice to the charge holders. Dear debenture holders, I received a notice from your company that it repaid everything and they are asking for satisfaction. Did they repay? Then 14 days time now I will give to charge holder to reply. If they are silent, I will register the satisfaction of charge. If they are not silent, they reacted saying that no, still it is not repaid, then they will not register the charge. So if the cause is shown, ROC shall record a note to effect in the register of charges. If no cause is shown, ROC shall order entering of memorandum of satisfaction in the registration of charges and inform the company. ROC shall issue certificate of registration of satisfaction of charge in form CHG 5. In form CHG 5. Sir, we read CHG 1. Company to register the charge other than debentures. CHG2, ROC certificate of registration. CHG3, ROC certificate of modification. CHG4, this one, notice should be given to intimation should be given to ROC about satisfaction form CHG4. ROC will issue certificate of registration of satisfaction of charge in form CHG5. So 14 days time we will give. In 14 days, if we react, fantastic. If we do not react within 14 days, okay, we will register the charge and issue certificate of registration. Next. Power of registrar to make entries of satisfaction and release in the absence of intimation from company. This section empowers ROC to make entry for satisfaction and release of charge even if no intimation was received from the company, because registration has to be done actually by company. Did not do, charge holder can do. Like that satisfaction also, if company is not doing it, ROC can himself do in the benefit of charge holders. See, if the evidence is shown to the ROC that the debt secured by charge is paid or property is released from charge, okay, then he may enter in the register of charges the memorandum of satisfaction that the debt is satisfied in whole or part or property is released. Again same, CHG file he can give. Okay, are not that important concept. Next, last one that you need to read as a concept, important one, 87. Rectification by central government in the registration of charges. See, very important for your attempt September 25. Chance is there this can come. That does not mean read only 87. If expected question I put 87, you have to read only 87. We are reading everything, but 87 is the most important out of all. Like that you should understand the spirit of a professional. See, this section empowers CG to order rectification of register of charges in following cases. Means MCA register law already some data is there. That data I only filed, but I mistakenly filed some erroneous information. I am asking for changes. Can it? Yes. See, omission in giving intimation to ROC for payment or satisfaction of charge within time. Means company failed to intimate the ROC. It want extension. Go to central government. Omission, see, omission or misstatement of particulars in any filing made to ROC, such as charge creation, charge modification, charge satisfaction, okay, or any mistake is there in the register, then we can ask for rectification. So CG may, on application filed by company or by interested person in form CHG8, rectify omission or misstatement in the record and extension of time for satisfaction of charge. Sir, why sir extension is required for satisfaction of charge? 30 days plus the 30 days plus the 60 days is given only for registration of creation and modification of charge, not for satisfaction. Satisfaction ki what we write, within 30 days of repayment, you have to intimate. Extension 30 plus 60 does not apply there. Then you have to go to central government. So central government 87 section will get attracted, not for all the extensions. Extensions for satisfaction of charge, okay, or for rectification in the register. So 87 section is applicable in two cases. What are the two cases? Number one, rectification of register errors. Errors in the register. Errors in what? Errors in registration of creation, modification, satisfaction. In any of these mistakes are there. Rectification I will ask to the central government because it is in MCA website. Okay, MCA is in the central government hand. I will apply in form CHG8. Or normally whenever the loan is repaid, you should apply for satisfaction within 30 days. You did not apply. Okay, I wanted to go for extension. 30 plus 30 plus 30, 60 does not apply here. So you have to go for central government extension. That's it. With this, we have completed entire charges chapter. All core contents of charges is completed now. First of all, everyone reply, are you all confident up to here or not? Everyone. The entire charges chapter, everyone understood clearly? Okay. So now, within 2 hours, we have completed entire areas of deposits and charges. As I promised you, 1 hour has taken for 1 hour, 10 minutes have taken for deposits, 55 minutes to 60, 45 to 50 minutes taken for charges. we completed two very core areas of your company's act portion has been completed just in 2 hours. First of all, everyone tell me, are you all satisfied with the session or not? You can give an honest reply to me. Did you all satisfied with the session or not? Are you feeling the session as useful sessions or not? This 2 hours time. Okay. Yeah. Now we are going into next area. Okay, we are going into next area called as incorporation of company. Which one? Incorporation of company. But before going into incorporation of company, let us take a 15 minutes gap. Continuously, no one can read. Even my voice also will get affected. Okay. So what we will do is we will take a 15 minutes gap, reassemble again. Then we will cover incorporation of company area. Okay. Another 8 marks area for this attempt here. Please don't miss it. Continue. Can we continue? Two minutes will begin. Everyone please reassemble. Start. Join fast. We'll begin with the incorporation chapter. Yeah, let's begin. Now we are going into a 8 marks chapter. Damn sure comes in exam. Name of the chapter, incorporation. Okay. Okay. Let's begin. Second part of the session is going to be much more violent than the first one. So please listen carefully, because these aspects will come for 8 and 5 marks. One chapter will come for 8 marks, one chapter will come for 5 marks. So here we are going to start with a revision of 8 marks chapter in exam, incorporation. Which one? Incorporation. Let us focus on what is this incorporation chapter. let us touch all the concepts that are applicable for your exams. Okay, so let us revise. See how revision should be. First of all, let us understand the scope of the revision. Every section, almost 90% of this chapter, let us cover. Let's not leave anything. Unless and until there is only a small aspect which we can negligible and we can leave it for your revision, I will leave. Remaining each and every minute of the details we have to complete in the class. Number one, the moment we complete revision of this chapter, you should not again open the book. In the yesterday schedule, I have given you one point there. What point I said? Revise the live chapters. 1 hour time I have given. At that time only you should revise. Means how much concentratedly you should spend this 4 hours. Already 2 hours completed. Still another 2 hours I will spend with you. We will complete this. This 4 hours, whatever we completed, you should not touch again. Tomorrow 1 hour I have given you to revise all the live concept. Tomorrow, today last, somewhere I have given 1 hour time for you to revise everything. At that time only you should revise these 4 chapters. Means after completion of this live, follow the schedule properly. 70 plus, why it will not come, I will see. Okay, let's begin. Let us now start with incorporation and incidental matters. I am going into the main aspects to complete. Okay, first, let us focus on section number 3. Section number 3. Purpose of incorporation. Only for a lawful purpose. Means companies cannot be incorporated for illegal or unlawful purposes. Next, association means group of people. Public company ki 7 or more, private company 2 or more, OPC ki 1 person. They should become subscribers to the memorandum. Next, members severally liable in certain cases. Members severally liable in certain cases. Means what? See, I will give you a diagram. With the diagram, you can definitely understand. What is the diagram? See here. Number of members in a company. Let us say private company. There are 2 members. There are 2 members. Incorporated in the year 0. Year 0 under today. Till year 5. Till, or I will write this way. Till year 5. There are 2 members. There are 2 members. In the year 5, 1 member went out. Totally became how many now? 1 member. How many? 1 member. They continued like this for, say for example, 8 months. How many months here? 8 months. After that, in the year 5 plus 8 months time, they again appointed another member, making it 2 members. Now the question is, who will be liable in this gap period of 8 months? Is a question. Law says like this. For the first 6 months, company will be liable for the acts done by the member. However, filling is done within 6 months or within 8 months or 8 months. Extra 2 months is there na. For that, member become personally liable. That's it. This is what I wanted to discuss now. Everyone please answer. Did you all understand this concept clearly? Members to be severally liable in certain cases. Hopefully you understood this particular concept now. Section 3A. Read this. I am making it full screen. Read this. That's it. This is the time I am going to give to each section. 3 minutes to 2 minutes. That's all. Okay. Understood the chart clearly, everyone? Okay, wow. Everyone. If you are completed, let me know. We'll go into the next one. Done. So when section gets attracted, when the number of members fall below statutory minimum, public company below 7, private company below 2. In the first 6 months, company can continue to carry on the business. Company can contract its debts. Okay. Company shall be held liable for all the debts and obligation. Next, after 6 months of the fall, general case, company cannot carry on the business in its own name. Violative case, if company carry on the business and contract the debts even after 6 months, then company not liable. Members who are aware of the fact will become jointly and severally liable after 6 months till you fill. The moment the filling is done, again company will become liable or responsible. Everyone please answer, understood the concept up to here clearly? Now, next one, clauses. There are totally 6 clauses of memorandum: name, situation, objects, liability, capital clause, and association clause in case of other than one person company. Okay, in a normal company, in case of OPC, nomination clause. Next, one by one clauses, let us see what we are going to see. Clauses. Okay, please. First one, name clause. Section 41A, proviso to section 41A, 42, 43, 44, 45, all concepts put together, we are going to put in one single chart. Okay, contents. Name clause contains the name with which company is proposed to be incorporated. Okay, name clause will contain the name with which company is proposed to be incorporated. Public company, limited, private company, private limited, one person company, OPC you have to clearly write down. Okay, OPC you have to clearly write down. There's a small spelling mistake, I rectified. So name clause contains the name with which company is proposed to be incorporated. Public company, use the word limited. Private company, private limited. OPC you have to use at the end of the name. Next, exemption. Section 8 company need not use the word limited or private limited at the end of its name. Need not use. Next, prohibitions and restrictions. Prohibitions. Let us see what is prohibited. Okay, in the name point. First one, name identical or too nearly resemble. It is prohibited. Means what? Name of the company you are going to use should not be similar or identical or too nearly resemble to the name of an existing company. Next, second prohibition. Name shall not give false impression of government patronage. Patronage means what? Support. Okay, I use the word XYZ brackets like AP Limited, Andhra Pradesh. Means what? When a person see that, he will understand it's a government supported company, but it's not. Since I am from Andhra Pradesh, I have written that name, which is wrong. That's what he wanted to tell. So name should not give false impression as if government support is there to you. Don't do that. That's the next point. Next one. Name is offensive. Name is offensive in the opinion of central government. Name is offensive. These are all prohibitions. What are prohibited? Name should not be identical or too nearly resemble to the name of an existing company. Name should not give a false impression of a government patronage. Name should not be offensive. Over. Next. Restrictions means what? These are not prohibited. These are restricted. Means with the permission you can use. What are those? A company may use the word national, board, commission, Bharat, etc. with the previous approval of central government. Very good. It can use the word insurance, bank, venture capital, mutual funds, all these, financials, etc. with the approval of regulatory authority. Sir, what do you mean regulatory authority, sir? Insurance if you wanted to use na IRDA, bank if you want to use na RBI, venture capital, mutual fund, Nidhi na take the permission of SEBI, like that. The respective regulatory authority. Next one. Name reservation. Name reservation. See, reservation of name can happen at 2 different stages. Number 1, when you incorporate, before incorporation, first you will reserve the name and incorporate. Means at the time of incorporation for a proposed company, you can apply. Or sometimes company wanted to change the name. I wanted to change the name from XYZ Limited to ABC Limited. XYZ Limited to ABC Limited. You wanted to change it to what? ABC. First you have to reserve that ABC name and then you have to change. So reservation can happen in 2 places. Number 1, reservation can happen at the time of incorporation. Post incorporation also reservation can happen. So at the time of incorporation, after getting incorporated, existing company. Okay. Next, apply in web form, apply in web form, Spice Plus along with a fees of 1000. Okay, so you have to apply for name reservation in Spice Plus form directly. Name will be reserved not for infinite period. Name reserved will be valid for a period of 20 days from the date of approval. How many days here? 20 days. Okay. Next. If there are any defects, you will be given a chance to re-upload it within a period of next 15 days. Next. Sir, mine is not a old company, new company, sir. I am already incorporated, sir. Okay, incorporated long back. I am going to change my name. In that case, what will happen? If you are an existing company, you need not apply in Spice Plus because Spice Plus is an incorporation document. Then you have to apply in run form. Then you have to apply in run form. Run means reserve unique name. 1000 rupees same. Validity period 60 days from the date of approval. 60 days from the date of approval. Okay. Listen. Sir, I have a doubt, sir. Actually, this doubt should come in class, but still, you find anywhere, Companies Act, it requires lot of reasoning than saying what is there. Here 20 days, here 60 days. Why? Generally, people will read, new company, remember 20 days, old company, remember 16 days, 60 days, like that they will remember. But there should be some logic with the government. There is a logic. What is that? New company will propose a name. Okay. ROC will approve. After that, your incorporation process will start. Is what law is saying? You reserve the name, put one name, apply for incorporation, complete the incorporation process in 20 days. This is the logic. Existing company wanted to change the name. If existing company has to change the name, first board of directors have to conduct a meeting, propose the name change. They proposed. After that, shareholders should pass a special resolution. To pass a special resolution, general meeting must be held. To conduct a general meeting 21 days before, I should give a notice. If 21 days notice time is there, means within 20 days, how can I change it here? Fool only will read like that. That's why shareholders' permission has to be taken. Name change requires central government approval also. That means I should apply for central government approval, wait for central government approval. Central government has to give the approval. I need to file it with ROC. Then all these things will happen. That's why existing company name change is 60 days time. New company ki anyway resolutions are not required. 20 days time was given. Now you will never forget in life. Do you understand the point? Everyone, did you understand the point clearly? That's why they kept like that. That's why provisions came that way. Why 30, sorry, why 20, why 60? That's the reason. There are a lot of things to do. So that's why it came. So always Companies Act reasoning is required. Seeing the chart and reading, any fool can do. Even if you don't know Companies Act, put the chart before get. If you read, answer over. But the cream, the layer is added. Okay. What's special with Bhaushik Munkesh means what should be there? Reasoning. Why section came like that? Everyone will read what is there inside. But you should understand why. Why lawmaker is bringing like that? If not like that, what could have happened? If 20 days is there, what problem will come? If you concentrate on that, life will never you will forget Companies Act. Same we are doing also with income tax now. I will be coming live also for income tax in my style. Each and every point in the Bear Act we are doing, we are tearing the sections, we are tearing the words. Each and every point we will analyze such that if you qualify, you will set your practice. You will become a professional, you will become an expert in income tax. Each and every minute detail you have to understand. That's why I said, a fool also can read from the charts. Just to put in the chart, if you read, a fool also can do that. Even though you don't know the logic, you can read it. But professionals in practice are earning in lakhs, not by reading, by absorbing the idea of the makers of law. Why it was made like that? That makes you a perfect professional, not just like a fool reading the charts. I'm seriously telling you, on Teachers' Day, if I really have to tell my students one thing, please do not mug up subjects. Understand the subject matter and then only you read. In life, no one can stop you because they can steal money, they can steal everything, but they can't steal your knowledge. Na? So that's it. So that's always a pride for a professional. They can't steal your knowledge. They can steal anything from you. They can steal people, they can steal money, they can steal properties, but they can't steal your knowledge. So keep in mind always, don't encourage any nonsense in life. When you are reading law, law has to be read in the way in which it has to be read. The income tax same, companies act the same, GST are same. Learn in a proper way, such that when you qualify, there is a value for that qualification. Or else, people are seeing some chartered accountants like a fool. They don't know anything, just reading all these things. So please have that clarity in mind when you are reading something. Clear? Let's begin. So now what we completed, name clause in one chart, we completed everything. Knockout. Additional concepts in name clause. This is the next important thing. What is this? Rectification. Which one? Rectification. One line I will tell. I applied for a name. That name was similar to another company. Website la no error shown. I uploaded. Name also approved. Company also got incorporated. Later, central government found that by mistake, central government approved the name. Mistake is not with me. Mistake is with the government. Therefore, see, type 1. Name is identical or too nearly resemble to the name of an existing company. So, name is similar or identical to that of name of an existing company. Actually, software has to detect the error and stop. But it did not. So, central government shall direct to change the name of the company by passing ordinary resolution within 3 months. Because mistake is with the central government, no special resolution. Ordinary resolution is required to change and within 3 months. Next one. Type 2. My name is not similar to the name of a company. My name of a company is similar to the name of a trademark. Then no complaint from proprietor of registered trademark. Complaint not received. No action will be taken by CG. Complaint received from proprietor of trademark. But complaint is made within 3 years from date of incorporation or date of change in name. Then CG satisfied na, direct to change the name. CG not satisfied na, no action will be taken. Again ordinary resolution in 3 months. In any other case, means what? Complaint is made after 7 years of using the name. Then no action will be taken by central government. Okay. So what is the meaning here? If name of a company is similar to name of another company, company name is in the records of MCA, is in the records of this also logic again. You will get a doubt that, sir, first type no one need to make a complaint. Second type proprietor of trademark should make a complaint to CG, then only CG will order for change in name. Why, sir? Here no one need to require to make an application, but here application is required. Yanna pakshapatam, yanna all these things. Like that you will get a doubt. There is a logic also for that. What is the logic here? Name of a company is similar to name of another company. Company names are already in MCA database. So similar, identical I can find out. Trademarks are not in MCA website. No, those are in different websites. Trademark websites, it will be there. How come MCA will know whether your name is similar to trademark? That's why owner of the trademark should come and make a complaint. That complaint should not come 20 years after. 3 years, within 3 years of incorporation of that company or change in the name made by that company. Within 3 years. Not from trademark registration date 3 years. 3 years from the date in which a company is using the name of its trademark. From that date, 3 years. You have to make a complaint. You make a complaint immediately, government will not tell. It will again check whether really name is similar to trademark or not. If name is not similar to trademark, means central government not satisfied, no action taken. If central government is satisfied, then it will direct to change the name by passing ordinary resolution within 3 months. Okay, so you will get a doubt. Sir, these many points are there. See, just for your clarity sake, I am telling. See here once. On application made by registered proprietor of a trademark that the name is identical or too nearly resemble to the registered trademark under trademarks, etc., made to the central government within 3 years of incorporation, whether under this act or previous law, in the opinion of central government, it is identical. That minute aspect also I kept in the chart. Central government should be, it should be of opinion. It should satisfy that really it is too nearly resemble. Just because of the reason the trademark owner made a complaint, I will not stop. I should also feel that, I should also get satisfied. I should also form an opinion that really it is too nearly resemble. That means from this what you have to understand, I did not prepare the charts by copying any other book. My copy is from Bayer Act directly. If you read Bayer Act, then only minute of the details of law you will understand. That's what we are also doing in DT. Okay, for your understanding, I'm telling you, I will upload after another 3 days. For Jan attempt only, one chapter I'm going to upload. Do you know what is the chapter? House property. Okay, agricultural income. All these PGVP, all these I have done. Okay, agricultural income we have taken 29 hours almost. Why? Each and every minute detail of section number 2 class 1A we made the post-mortem. Every point I made a post-mortem. Why this came, how this came, what is the logic, everything. Like this Companies Act, the words are very, very important. CG, if it is satisfied, then only this will get applied. Exam, you have to write in the same way. CG is also of an opinion that really the name of the company is too nearly resemble or similar to that of the name of an existing registered trademark, then it will order the company to change the name within 3 months by passing a ordinary resolution. Everybody answer, understood the concept clearly or not? Everyone. You should reply. Once you reply, we'll go to the next one. Yeah. Next, alteration. Whenever you wanted to alter the name, very important here, listen carefully. What approvals are required? Board of Directors, shareholder special resolution, central government approval. Why CG approval? CG, when you apply, then CG will see whether the name is undesirable, offensive, patronage of government, all those things they will check. That's why. Next, exemption from CG approval. When CG approval is not required, I am not changing my body of the name. I am not changing. Suffix only I am changing. Means what? My company is XYZ Private Limited. I am converting it into public. It becomes XYZ Limited. Or my company is actually limited. XYZ Limited. I wanted to convert that into private. XYZ Private Limited. Now XYZ anyway is not changing. Na? Private is becoming normal limited or limited is becoming private limited. Means either private is removed or private is added. In such case, since the body of the name is not changing, only the suffix is changing, liability is changing, there is no requirement of CG approval. When the only change is addition or deletion of the name private at the time of conversion. Other compliances. Comply with 4.2 and 4.3. Name should not be undesirable, offensive, all these. Comply with the procedures of section 13. Section 13 means memorandum alteration. We will see there. File a copy of special resolution and altered MOA with the ROC. If you want, you can add one point. Copy of special resolution. Inform MGT 14. Inform MGT 14. Okay. Other compliances also over. Duty of ROC. Make the changes in the register. Make the changes in the register. Make changes in register. And issue fresh certificate of incorporation. See, 2 charts we completed all the concepts inside the name clause. Everybody please answer, are you all satisfied up to here? Once you say yes, we will be going into the next one. Name over. Next we will go to situation clause. See, here when I say answer yes, na, you should tell whether you revised or not. Again, after the class, there is no revision for you. That's it. It's the last revision for you before going to exam. Okay. Next. Situation clause. Which clause here? Situation clause. First, all about the registered office. See, please concentrate. we are going to read 4.1b along with section number 12. Expected question for this attempt. I have given in the expected questions list also. Contents. What registered of situation clause will contain? State where the registered office to be situated. Okay. Next. Rules. Establishment of RO. When I have to establish a registered office? Within 30 days of incorporation. Registration is enough? No. After setting up a registered office, you should file verification of registered office within 30 days to ROC. So, within 30 days, two things you have to do. Establish RO and file verification form also with ROC. Next, disclosure requirements. See, whenever you have a registered office building, four things are required. Number one, paint or affix. Painting means you have to paint it. Affix means directly you can establish a board there. On what? Details. Name and address of RO. Okay. That board should contain name and address of RO. Place. Where I should put, wherever you do the business. For example, my main company is in, say for example in Hyderabad, my main company is in Jubilee Hills. There I should put. I have branches in Banjara Hills, also in Gachibowli. So both the places I should put the board again. So wherever you are doing the business, outside every place of business you should put. Now question, sir, I will put a small board this much size. No, it should be in conspicuous position. Means it should be in a proper position so that public should be able to see. In legible characters, cursive writing, unidentifiable font, you should not write. Okay. In which language? Local language and any other language. First local language. After that you write in any other language you want. Okay. So now paint or affix. Number one, name and address of RO. Number two, outside every place of business. Number three, in a conspicuous position with legible characters. In which language? Local language and any other language you want. Next, seal. On the common seal size this much. On that name, address of RO, how will you write? Therefore, on the common seal, name only should be engraven. Name only required. Next, printing. Documents. So many details. Document, so much space is there. You can print all. So name, address, SIN, phone number, fax, email ID, website, everything you have to. Next. And place on all the business letters, bill heads, letter papers, simply all official publications, documents, everywhere, you should write the full details. See here. I will tell you how to understand this point. See, what you should place: name, address, SIN, phone number, fax, email ID. All these full details should be there. Where? On business letters. Means when you communicate. Invoices, bill heads, temporary bills, notices, any official communications and publications. In all those, you need to put all the details. That's why whenever you see letterheads, full page, 1/4 they will take for company name, address, website, phone number, SIN, all details they will give, GST numbers and all those. That's because of this condition only. So this is print, this is also print. Print what? Name of the company, place on all negotiable instruments. Check is there. Directly we will put the name. ABC Company Private Limited, like that. Check I will read registered office, website, all those. Check only name of company. So what you have to understand? Disclosure requirements with respect to name. Number one, name and address of registered office, all the, outside every place of business, in a conspicuous position, local and any other language. Seal, name only is required. Next, name, address, in every detail should be there on all documents. Next, negotiable instruments, the name should be printed. Okay. This is part 1 of registered office question. Section 12, half the section we completed now. Please read the chart for a minute. And you should reply me whether you are understanding the point up to here. If you are done, please let me know. We will go into the next one. you are done, let me know. We'll go into the next one. Everyone? Yeah. Sir, you please also let your friends to also know this. Share it whenever it is possible, because once they complete the revision, chances of clearing this particular subject with good amount of marks, chances are very heavy. So my request is only share it with your friends as well, such that more number of people will be benefited. Okay, let's continue. Next one, shifting of registered office. What is the concept here? Shifting of registered office. Very important concept here. Expected question, this is also there. Listen, there are 4 kinds of shifting. Easy way I will represent. Shifting from place to place within same city, city to city within same state, ROC to ROC within the state, state to state. I repeat, place to place within city, city to city within state, ROC to ROC within state, state to state. First, section governing. All those sections are there. So I wanted to change from Jubilee Hills to Banjara Hills in the same city of Hyderabad. Then board of directors, board meeting only. No, sir, I wanted to change from city to city. From Hyderabad to Vijayawada, I wanted to go, but within the same state. Board of directors at board meeting. Okay, first approval. Second approval will be special resolution also required. Central government approval not required. By the way, I forgot. Here also central government approval not required. No special confirmations required. 4 points. Board required. Approval 1, approval 2, alteration, special confirmation. Next. No, sir, I wanted to change from ROC to ROC within the same state. Board of directors approval. Special resolution approval. Alteration memorandum not required because state is not changing. ROC is only shifting. But regional director confirmation is required. Who's required? Regional director confirmation. What is the procedure? Company should apply to the RD for confirmation. Further time limit is not there. You apply. RD should issue confirmation within 30 days. If no, also you should tell within 30 days. Then confirmation notice given by, okay, just a minute. Then confirmation notice given by RD. Then what notice here? Confirmation notice given by RD should be given to the company within next 30 days. So start again. Next 60 days. See here. First point number 1. Company should file a confirmation with RD. RD will give confirmation within 30 days. That confirmation notice given by RD should be filed with ROC within 60 days. On that basis, ROC will register the new place to be the register office of the company within next 30 days. So how to remember 30, 60 and 30? See, I wanted to change from ROC to ROC. Say for example, I wanted to shift from Chennai to Coimbatore. 2 ROCs. Chennai ROC is there. Coimbatore ROC is there. I wanted to change from Chennai to Coimbatore. How to do? First, company has to apply to the RD, regional director. For the Tamil Nadu, there is a RD in Chennai. To the Chennai RD, they will make a petition. RD will really check whether there is a need to change from ROC to ROC or not. If he really say yes, he will confirm within 30 days. RD once confirmed, you have to file the RD confirmation with ROC within 60 days. Taking that confirmation notice, ROC will change your registered office address, everything in the records of MCA within next 30 days. This is the procedure that should be followed. Next. No, sir. I wanted to change from one state to another state directly. One state to another state directly. Board of directors at board meeting. Shareholders by passing special. Central government alteration of MOA is required. Alteration of MOA is required. Along with alteration of FOA, central government approval also required. In all these cases, central government approval is not at all required, but here it will be required, state to state. How? Procedure, again procedure. Step 1, company will apply to CG. CG will issue its approval within 60 days. But when CG will give its approval, three conditions. Either condition 1 or condition 2 or condition 3. What is the condition 1? Consent of the creditors and debenture holders is taken. So, no, sir, I could not take. At least sufficient provision you should create to pay them. No, sir, that also not there. At least you should show that there is an adequate security to pay them. If any of these three, either this or this or this, see, a simple logic I told in the regular classes very clearly. Whenever you are shifting in the registry office, okay, heartla dar will start to the creditors, because if you run to a remote place, they can't approach the company to complain. Therefore, whenever you are changing a registry office, take the consent of creditors. No, sir, I can't take now. Lot many creditors are there. At least to show me that you had a provision. For example, debentures are there, 1 lakh. DRR, 70-80,000 is already created. Means what you have to understand, even though you did not pay, a good amount of, provision is already created. Happy. Sir, I could not take permission and I could not even have a sufficient provision also. Then what to do? At least to show that for this much creditors, this much assets, security is also available. Means what? If you sell all these assets, easily I can pay. At least that way you have to do. Okay. So, step 3. Which one? Step 3. Company should file CG confirmation with ROC of both the states. Company shall file CG confirmation with ROC of both the states. Because we are shifting from one state to another, both the states. Duty of ROC. Register the change. First case, city to city. Place to place in city. Here also same. But in the last state, change will come. ROC of the state to which RO is shifted. That means new ROC is there, na? That ROC will register the change and issue a fresh certificate of incorporation. So read this chart properly. One chart I tried to cover every detail inside the change in registered office. 2 minutes time I will give. Please read it properly. Please read properly. Everyone, please complete it fast and let me know that you completed. We'll go to the next one. Okay, next one. See here. Now let us fuel up. Let's complete it fast from now. Objects clause. Whenever the objects clause is concerned about, objects clause will contain the object for which the company is proposed. I wanted to alter the objects clause. Okay. General case, special case. General case. Normally I wanted to change the objects clause. First, board of directors, shareholders by passing a special resolution in general meeting, alter MOA. Compliances. Company shall file with ROC copy of special resolution altered MOA within 30 days. Same procedure like name and situation. ROC shall register in 30 days. That is same. But objects clause change do not require CG approval. This you have to remember. Next, special case. Listed companies wanted to change. Not all. Some specified listed companies. Which kind? That listed company accepted money from public by issue of prospectus and the amount is still unutilized. Such a kind of company, if it goes for alteration of object, first approval 1, approval 2 same, means board approval, shareholders approval is same. Compliances, advertisement in 2 newspapers and exit offer to dissenting shareholder. Those shareholders who are opposing this, you took money by saying one object, now you are changing that object. We don't wanted to stay in the company, we wanted to leave. Like that some people may oppose. Those people are called as dissenting shareholders. Exit offer you give and send them. And other compliances, same in general case. That's it. Next. Other clauses of MOA. These I don't wanted to discuss and waste my time. See. Articles. I don't wanted to discuss what is articles, a foundation thing. I wanted to talk about the new thing called as alteration of AOA. Whenever you wanted to alter AOA, step 1, board of directors at a board meeting. Step 2, shareholders by passing a special resolution in general meeting. Compliances, comply with the act, comply with MOA. Whenever you pass a special resolution, always one thing you have to remember. File MGT 14 within 30 days. ROC shall register the change. Okay. Next one. Mark this important here. Exam this time expected. Mark this important. Conversion cases. Mark this important. Conversion cases. They will definitely ask this question in exam because no one is reading, but utter flop answer will be written. Therefore, please be very careful. Listen to this concept. Very, very important for exam. Expected question for this attempt. Let's see. Basic condition. See. Conversion cases. Which one? Conversion case. What conversion case? See. Conversion related to what? I wanted to convert any class of company into any other class. What are the conditions? Alteration of MOA. See, you wanted to change from one company to another. I wanted to convert OPC into normal company, Section 8 company into normal company. Any conversion, first alter your MOA because objects have to change. Alter your AOA, special resolution. Then board of directors at a board meeting. So alter MOA, alter AOA, and then pass a special resolution for conversion and compliances. Refer note. See, here I have written the note. Company shall file copy of special resolution, copy of altered articles, and copy of central government confirmation to the ROC within 15 days. Within 15 days. So, company has to apply. Company has to apply. Sir, copy of special resolution understood, sir. Altered articles understood, sir. But copy of CG confirmation, where CG confirmation is there? Here, section 14. If the conversion is relating to public to private, private to public or public to private, okay, then compliances. Section 18, all compliances. Type of conversion, private to public, private to public. When you convert private to public, private has restrictions in transfer of shares, limit the number of members to 200, prohibit public subscription. Now all those should be removed. So no longer impose restriction on total number of members. Limitation on number of members 200, restriction on transfer shares, limitation on total number and prohibition. So no longer imposes. Public shall include those restrictions. Required only if the conversion is made from public to private. Then central government approval is also required. So if you are converting a public into private, then central government approval is required because public there are lakhs of shareholders. Private there are 200. How you are going to settle to all the remaining people? That's why CG will involve. Okay. So now, listen carefully. Tell what we are reading now. We are reading conversion cases. Conversion of what into what? Conversion of any one company into any other class of company. Condition 1, alter MOA. 2, alter AOA. 3, special resolution approval. 4, board meeting approval. Next, company has to file with ROC 3 things. Copy of SR, copy of memorandum articles, both. Third one will be copy of central government confirmation. When CG confirmation is required, if there is a conversion of public into private, then it will be required. Okay. Debts, obligations and contract shall continue in the name of converted company. Conversion of OPC into Section 8 is not permitted. One conversion not permitted. OPC into Section 8 is not permitted. First of all, everyone please tell me, understood the concept clearly? Everyone should reply. Understood the concept clearly? Okay. Okay. Done. Next discussion. Doctrines I am not going to discuss here because foundation syllabus. Just read this. Read this after completion. Chart is there. Na? Doctrines you read later. I am going into the main concept. Okay. Next. From here, all the concepts generally students are leaving. Okay. All these concepts generally students are leaving these concepts and going to exam carelessly. They are asking questions gone. See, first one. Alteration of, from here 2 minutes ki one section. Okay. Alteration of MOA AOA to be noted in every copy. Alteration of MOA and AOA to be noted in every copy. See, general provision. Any alteration made to MOA AOA shall be noted in every copy. What do you mean by that? Whenever you alter MOA or AOA, next reprint will be happening. Na? After alteration, you will print the. In that print, alteration after only you should print. Next, penalty. Company and officer in default shall be liable for a penalty of 1,000 per issue. Okay, if you don't do 1,000 per each issue, penalty will be levied. Next, copies of MOA and AOA to be given to every member. Every member. See, request by whom? Member. Request for what? Copy of MOA, AOA agreements. Penalty for default. If you don't give, this is the penalty. Time limit. Within 7 days of request, you should send them copy of memorandum or articles or any agreement. Yesterday in the penalties also I discussed this point. Effect of MOA, AOA. Hey, listen. This is expected question for this exam. Okay? Listen now. First of all, impact of registered MOA, AOA. Impact of registered MOA, AOA. First I will tell you, listen carefully. MOA, AOA will be registered. Always registration happens on a document. Entity will be incorporated. Company is not registered. Company is incorporated. MOA, AOA are not incorporated. MOA, AOA are registered. Registration applies to MOA, AOA. Okay, incorporation applicable for company. But sequence is important. Registration after incorporation. Incorporation after registration illa. First incorporation will not happen. First registration will happen. After registration, incorporation will come. Clear? See, whenever the registration of MOA, AOA happens, what will happen? Company will come into existence. The moment company comes into existence, all the members and company are having a silent agreement. What will be there? Silent agreement will be there. What do you mean by silent agreement? Though people don't sign, it creates a binding impact. Okay, I will explain. See, company memorandum and articles will be signed by subscribers to memorandum. Will be signed by subscribers to memorandum. In a public company, subscribers to memorandum should be, okay, 7. private company 2, one person company 1. These people names are written in association clause. These people names are written in association clause to the memorandum. From this, what you have to understand, association clause to the memorandum, we will be writing, I repeat, association clause of memorandum, we will be writing the names of subscribers to the memorandum. Subscribers to the memorandum, their names we will write in association clause. Once a company incorporated, the association clause will be closed. What do you mean by association clause is closed? You can't alter that clause at all. And you can't add anything, you can't delete anything. Okay? These 7 people in public, these 2 people in private, that 1 person in public, 1 person is there, na? Those people only sign on MOA, AOA. Okay? Later, company may get 1 lakh extra members, public issue. Those people don't sign on memorandum. When they don't sign on memorandum, what is there in the memorandum, they did not agree actually. Correct? Hey, there is a book here. In that book you signed. Means you are agreeing. I did not even sign. Nyayama pata, I did not even sign here. That means I am not responsible for that. But still, because of section 10, once MOA AOA is registered, it creates a binding impact between company and the members. Company and the members. 3 situations will come. MOA AOA something is written. Every member is entitled and obliged to have an obligation to observe the contents of MOA AOA. Understand in a right sense. It's like a constructive notice for the members. Something is there in MOA AOA means every member, 1 lakh means 1 lakh members, are expected to, assumed to have knowledge of contents of MOA AOA. Even though you don't read, that's not my mistake. Okay? Means every member should act according to MOA and AOA with the company. I will act according to MOA AOA. Company also should be binding to members. 3 situations will come. Company bound to members. Members bound to company. Member will be bound to member through company. Sir, I did not understand. See here. First, I will discuss about member bound to company. Memorandum and article. Listen, sir, I am telling you again. Mind if you don't put here, you will be the first affected party in the exam. If they ask a difficult question, let any person go in their way. But those listening to the lecture today also, if they are unable to write, it's completely your mistake. You are cheating yourself. Listening, So, please listen carefully. Show me one video in entire YouTube. One video. You tag there if possible. Where section 10 was taught like this. We are putting efforts means please everyone concentrate. Okay? People don't even understand what is section 10. At that time, I am trying to explain each and every minute detail. What really the section 10 wanted to tell. So concentrate properly. Clear? Listen. Company to members, leave it. First I will discuss member to company. Something is written on memorandum, something is written on articles. Whatever is there, members should follow that when you are dealing with the company. Example. Company memorandum, company articles memorandum, I have written like this. Board of directors can make the calls. First call, second call. Whenever calls are made, within 14 days, member have to pay it. This where it was written, articles, we have written this. Once it is written like that, whenever call is made, member has to pay within 14 days. Member should not tell, you made the call, Companies Act, show me where it is written that I should pay the call within 14 days. Show me Companies Act. Companies Act, it's not there. Articles I have written. Articles I did not read here. I did not sign. I am not a subscriber. I came later. Section 10. Member is bound to company by whatever is there in memorandum. Articles. Number two. Company. Number 2, company also should be bound to member. When member is bound to company, company also should bound to member. Na? Okay, listen. Company memorandum article say it was clearly written. It was clearly written. Where? In the company memorandum. In the company memorandum and articles. It was clearly mentioned. Company should not forfeit. Company should not forfeit the shares of any member. The shares of any member. Unless a notice is given to the member and member do not react to the satisfaction within 21 days. Like this memorandum I have articles I have written. I have written in the articles. What I have written? I have written that company cannot forfeit. Okay, company cannot forfeit what? Company cannot forfeit the shares. Company cannot forfeit shares. Shares of whom? Shares of a member. Company cannot forfeit the shares of a member unless you give a notice to him and give a time for him to reply for 21 days. That was written in articles. One of the member within 14 days he did not pay the call. So his shares are subjected to forfeiture. Directly they forfeited without giving any notice. This is also invalid because like how member should read MOA and behave accordingly, company also should behave with the member by reading memorandum and articles only. Everybody understood the concept clearly? Everyone? Understood? Now let us understand the remaining part. Okay, so that's the first thing. So company bound by members are bound to company. Company also bound to members. Third one, member will be bound to member. Sir, member will be bound to member means what? If that fellow took loan from someone, I have to pay through company only. See, there is a these are all case laws in your study material. Listen carefully. I'm not telling any stories. See, member bound to member means what? There is a company. In that company memorandum articles, they have written that if any member wanted to leave the company, he can leave. We will not stop him. But existing members should take his shares. Let's not sell to outsider because private company, restriction on transfer of shares. Okay, don't sell to outsider. Existing members only should decide and take. Okay, now tell me what is happening. Member bound to member through memorandum. That's the answer. But memorandum is not bound, company is not bound to outsiders through memorandum and articles. Sir, what does this mean? I will give an example to you. See, I took a memorandum. I will take one person from our live. Okay, there are so many people in live now. I will take one person from live. I will take one person, let us say Pawan Krishna. Last person to message na Pawan Krishna is there. I have written in my memorandum like this. He is an outsider. I am a company. Okay, Pawan Krishna is there. I am company. Pawan Krishna is an outsider. I took memorandum. I have written Mr. Pawan Krishna, okay, chartered accountant, will work as internal auditor in my company. Who comes to the company morning at 5 o'clock, sprinkle water, broom everything, clean the floor, veranda, everything, and he will start his professional work at 9:30 in the morning, complete everything. He will go home at 12:30 at night on a monthly remuneration of 500 rupees. I have written like this. Understood? I have written like this. Now tell me, since I have written like this in memorandum, now Pawan Krishna will be liable to company. That's the meaning. Memorandum, if you write something, members will be liable. Member liable to company, company liable to member, member to member also liable. But company and outsider can't bring any liability because memorandum articles will bind members with company, not outsiders with company. Outsiders will be bound to company only through contracts, agreements. Separately, you have to write an agreement. Then only outsiders will become liable, or else outsiders ki company will not be liable, or outsiders also not liable to company. Everyone understood the point now? Now Pawan Krishna should understand first, irrespective of any other person. Understood everyone? Everyone. Okay. Now, next issue. So, there is a case law in your study material. I will tell the summary. Okay. I have written the summary here. binding effect between company and members, company bound to members, members bound to company. Okay, there is no binding effect between member with another member normally. Through company only they will be binding. No binding effect between company with an outsider. Company with an outsider. Case law. Major General Shanta Shamshed Jang Bahadur Rana versus Kamani Brothers Private Limited. What happened in this case law? These three also case laws are there in your study material. Read. Company in its articles has expressly said that MD of the company in its AOA expressed that MD of the company cannot be removed unless there is a proven misconduct. MD is not a member. MD is not a member. MD, see, Mr. Rana, Major General Shanta Shamshed Jang Bahadur Rana. I am using the word Rana. This Rana is there, na? This Rana is not cinema actor Rana, normal Rana. So this Rana, he is a member and he is also a MD. Company enters into contract with him saying that from MD position we can't remove you unless there is a misconduct. Unless there is a misconduct. Rana has been appointed as MD. He is also a member. What happened? Major Rana has been removed by the company as an MD. Even though there is no proven misconduct. Immediately Rana said, Anna Pakshapatam, I will go to court. So he went to court and filed a complaint. Court said that, Mr. Rana, you can be removed. He said, how can I be removed? Memorandum clearly it was said that I cannot be removed. I am also a member. Court said that, don't get excited. Point number one, you are a member. Yes. You are a MD. Yes. Removed. Yes. Without misconduct. Yes. Removed in which capacity? MD capacity, member capacity, MD capacity. As a MD, you are not a member. MD is an outsider. Memorandum can't be used. Articles can't be used as a tool to empower any outsider. So, outsiders are not protected by MOA, AOA. Understood the point clearly? Yeah. So, MOA, AOA creates a binding impact between company with members, not company with any outsider. Here you are an outsider as an MD. If you are removed as a member, now you tell me, I will save you. But MD is an outsider. Articles cannot bind MDs. Outsiders, it will not bind. Understood? All the students should answer. Understood? Next one. Incorporation concept here. Next one. Before going into incorporation concept, I have some important points. See. Those are 19, 20, 21, 22. 19, 20, 21, 22. In my expected questions list, these questions are there. Which one? 19, 20, 21 and 22. Let us see. 19. General prohibition. Subsidiary company is not allowed to hold the shares in its holding company. Subsidiary company is not allowed to hold the shares in holding company. Once you become subsidiary, post becoming subsidiary, you cannot hold the shares in holding company. No, sir. Once upon a time, before becoming subsidiary, I already hold. What about them? You can hold them, but on that you don't get any voting right. Okay? So, a subsidiary shall not hold shares in holding company. Not only I should hold, holding company shall not allot or transfer any shares to subsidiary. Simple logic. Yeah. Once you become a subsidiary, you are ineligible to hold any new shares in holding company. Exceptions. Shares held as a legal representative of deceased member. Means company is not, subsidiary is not holding in its name. One person is there, he died, his shares are transmitted to subsidiary. Means what? Subsidiary will not vote in its name. In the name of the deceased member, I will vote. So no problem. Exception. Trustee I am holding. No problem. Voting rights also available. But shares held even before becoming a subsidiary means X Limited, Y Limited, two companies are there. X Limited, Y Limited, two companies are there. On 1st April 2025, Y Limited held shares of 21% in X Limited. On 10th May 2025, X Limited hold 53% of shares of Y Limited. On 10/5, X Limited and Y Limited became holding company and subsidiary company. But Y Limited already held 21% shares even before becoming a subsidiary. What about them? Shares held before becoming subsidiary, you hold them, but no voting rights are given on that. Everybody understood the point clearly? Everyone understood the concept clearly? Can we go to the next one? Can we move on to the next one? Yeah. Next issue. 20, 21, 22, one question is expected. Please listen carefully. What is 20? 20 is talking about service of documents. 20 is talking about service of document. What do you mean by service of document? See, communication by third party, communication by company. First, communication by third party. Communication with whom? Company and officer. For example, Kaushik Mukesh wanted to communicate with company. Kaushik Mukesh wanted to communicate with the director of a company. Okay. Place. Where to send? Registered office. Mode. How to send? Registered post, speed post, courier, hand delivery and electronic mode. Okay. This is a third party communication with company or officer. No, sir. Company wanted to communicate. With whom? ROC or member. How to place? If it is ROC, at his office. If it is a member, at his address. House address or some address, whatever he give. Mode, post, registered post, speed post, hand delivery, courier, electronic means. What is the only thing that is added here? Registered post is also added. Okay. Next. Very, very important thing is, member may choose any particular mode upon payment of fee as decided by AGM. There are so many traditional investors are there in India. Who are they? Traditional. Means what? Old age people, yeah. Okay, they don't want any email because they don't have. They will tell clearly to the company, if you send by email, I have nothing to do with it because I don't use it. Most of 70 plus shareholders in India, 70 age plus, those all will adopt for registered post or speed post. Email zero cost. But if you have to send a registered post, speed post, it will cost to the company. That cost will be recovered from the members. How much to recover will be decided by members in AGM. That much you pay, we will send only by that mode. Okay, next. Authentication of documents, proceedings and contracts. Sir, what is authentication? Means a signing. Okay, signing of documents, proceedings, contract. Next one, signing of bills of exchange, negotiable instruments. Okay, first let us see the document. All documents except negotiable instruments, one section. Only negotiable instruments signing, one section. So all other documents, let us see. Any document, proceeding or contract which require authentication of company. Company is artificial person, it cannot sign. Who should sign on behalf of company? KMP or officer, means any director or any employee. Employee means not normal employee. CFO, CEO, that kind of employee. Authorized by the board. Can sign. So this is the point here. So any document, proceeding or a contract which require authentication of company shall be made on behalf of company by KMP, officer, employee authorized by the board. Last one, execution of bills of exchange. Execution of bills of exchange, promissory note, any other negotiable instrument by any person having express or implied authority. Express authority means clearly we said check should be signed by director A, bill should be signed by director B, promissory note should be signed by director C. Like that, if I tell, that's called as express authority. If I don't tell anything, generally who will do things on behalf of company? Directors. Any director can sign. Express means only that person. Implied means any agent. Who is agent to the company? Board of directors. So any board of director. This is with respect to the negotiable instrument. But any deeds of a company, if the company has a seal, if the company has a common seal, then any person acting as attorney under the seal shall sign. Simply, director has to affix the seal. Over. But if the company do not have a seal, any person authorized by, if company has a CS, okay, by a director and CS, they have to sign. If company do not have CS, two directors have to sign on the deed. When I say authorized, express only allowed. Implied authority, no director can sign. Sir, I did not understand this. Listen, I will explain. Negotiable instrument, normal, Express implied authority, anyone can sign. Expressly, if something is said, that person will sign. Nothing is said, any director can sign on NI. Negotiation, bills of exchange, note checks, etc. Adi okay, clarity. Deeds are there. Company is entering into a partnership deed. Because company can become a partner, no problem. So partner should be a person, that's all. So company is a person. So company is entering into partnership. Company is a partner. It has to sign. Who should sign? Adi deed. It's not a normal document like in section 21. It's not a negotiable instrument like in 22. It's like a deed as per 22 part 2. So who should execute? If the company has a seal, that's it. If you apply the seal, okay. If company don't have a seal, then director and CS have to sign. Sir, company the CS is not there. Then 2 directors have to sign. That's it. Director say, no other person can sign. Only express authority should sign. Okay. This is the point here. Everyone understood 19, 20, 21, 22 sections, Everyone, 19, 20, 21, 22 sections, everyone understood, Okay. One question will come in the exam. Enjoy. 6 is a small concept. I don't want to discuss and waste time. Remaining also, okay. Next. One person company foundation you already read. I don't want to discuss. Okay. 7, 8, 9 is only a procedure. I don't want to waste my time by discussing all those. Section number 8 important here. Charitable organizations, whenever they form, simple I will tell in 1 minute. Charitable companies will be a group of persons forming together without an object of making profit for science, social, education, welfare, art, or for religion or anything they will do. They prohibit payment of dividend and they do not entertain any kind of profits. Profits will be applied only for promotion of object. So company will be formed for promotion of commerce, art, science, etc. Intent to apply profits only for promotion, no dividend payment. Next. They will apply for a central government license. Central government, if it believes that really, if it will be doing that social activity, etc., it will give a license. If you do any kirkiri, license will be cancelled. Upon cancellation of license, you will be either converted into normal company or merged with another company having similar objects or directly go for winding up. This is the overall object of section 8. Just give one reading and leave. Okay. Section 7 will be talking about the concept of incorporation. Same CA foundation. Procedure will be there. Just read the chart and leave. Okay. Only a procedure. That's it. With this, we have completed another very important chapter called as incorporation and incidental matters. Everyone in live, please answer. Did you all understand the concepts inside this? Everyone? Okay. So with this, we completed entire incorporation area. Next, foreign company. So in this, I will not take much of your time here. I will complete it very fast. Give me 15 minutes time. How much here? 15 minutes. I will tell you the overall idea of this foreign company chapter. You can also read later. Charts are anyway available. Okay. First, in this foreign company chapter, the most important thing that everyone has to focus is definition of foreign company. 9 times asked in exam. Okay. But they are asking more on electronic mode. What a electronic mode. See, foreign company definition. Company should be incorporated outside India. Place of business is in India, whether by itself or through agent, physical or electronic. But what do you mean by electronic mode? See, meaning of electronic mode. Electronic mode means through internet you are doing the transaction. Where main server is located is irrelevant. It's not relevant. Main server may be in India, main server may be outside India. That will not decide the whether you are a foreign company or not a foreign company. It includes the following activities: business to business, business to customer, electronic data interchange, and digital supply transactions like Amazon. Next, it is not doing any business. It is accepting deposits or subscription from citizens of India. It is doing a financial settlements or telemarketing, telecommuting, etc. All these, whether you are doing that through email, mobile services, social media, whatever you use, electronic mode, if you are doing anything, it will come under electronic mode transaction. Just read this chart here, very, very important for exam. Completed? Completed, everyone? Yeah. Next one. Next one. See, generally, foreign companies ki Companies Act should not apply. Only to some extent it should apply. But entire Companies Act will apply in some cases. In some cases. What cases? They look like foreign companies, but control is Indian people. See, main content I will discuss. Companies to whom all sections of this chapter and other provisions also will apply. When, see, there is a foreign company, in that foreign company, not less than 50% of the paid up share capital, equity or preference or partly equity preference, whether singular aggregate, is held by Indian citizens or Indian companies or combination. So, everything should be clear. First, foreign company. That foreign company has share capital. In that share capital, not less than 50% is held by Indian people, Indian citizens or companies or combination. Then such a kind of company should comply with this chapter and other provisions also of this act with respect to its Indian business. Okay, read this chart. Exam expected question here, read this chart. Okay, done. Yeah, next one. Next one. See here, just a minute here. Next one. Documents to be delivered to ROC. What do you mean documents to be delivered to ROC? I wanted to establish a place of business. Directly you can't come and establish that. You have to take some permissions. You have to file some documents. What? See, 7 documents are required. Charter statutes. Statute means the bare act of that country. Country's Companies Act. Using what sections you incorporated company there. MOA, AOA or any other instrument defining the constitution of the company. Outside company is incorporated. Your charter means your constitution. Like India constitution, your constitution. Second, that means I should read that constitution, whether that country constitution is allowing to establish the companies outside India for the charter. Second one, statutes means what acts are influencing the incorporation. That statute. Generally, Companies Act outside India. Your MOA, your AOA and other documents. You send it to ROC. Number 2, full address of registered office of the company outside India. This is outside. Full address of principal place of business in India. India, I can have 10 branches, but one main branch will be there. That's called as a principal place of business. We shortly call PPOB, full address. Next, did you come to India before, went out, again coming now? If it is so, please tell the reasons also. Principal particulars of opening and closing the business in earlier occasion. Previously you came, you went back, again you are coming now. Why? Next, names of, see, foreign companies outside India and a registered office outside India. GST officer in India will send notice means they have to send to registered office outside India. They don't understand our GST. Therefore, every foreign company should have an Indian representative, authorized representative who is an individual. That fellow should be resident. So, name and addresses of persons resident in India who is authorized to accept documents on behalf of company. So, instead of sending to foreign company outside India, send it to the authorized representative in India. List of directors and company secretary. List of directors and company secretary. And declaration means confirmation that none of the directors authorized representative are convicted or debarred from any company in India or abroad. So, they are good persons only, not offenders. Okay. So, 7 things you need to file with ROC. Number 1, charter, statutes, MOA, AOA and other documents. Second one, full address of outside India registered office. Full address of place of business in India. Opening and closing in previous occasions. Okay. Next one will be names and addresses of authorized representative. Names and addresses of directors and company secretary. Declaration that they are not offenders. All these 7 documents throw on the face of ROC. Okay. In what form? FC1. Within 30 days of establishing POB. So, there is a changes. There are changes. FC2 within 30 days of alteration. Sir, I have PPOB filed. I have 10 branches. 1 head office and 9 branches. Head office detail I filed. Then remaining 9, file it along with the financial statements in form FC3. List of POBs in India. List of POBs in India. Next, accounts. Accounts. Accounts of whom? Accounts of a foreign company. A foreign company shall prepare balance sheet and P&L according to Schedule 3. And Indian operations you are doing na, prepare as per our schedules only, our Schedule 3. Not only that, attach audit report, board report, everything. And also attach consolidated financial statements submitted by your parent company in that country. I wanted to compare how much business you are generating within India and outside India. For that comparison, file CFS. Whose CFS? Parent company will be there in USA. For example, that USA company might have filed with their USA authorities that you file along with this. So, 3 things you have to file with ROC in India about your accounts. Number 1, P&L account balance sheet as per our Schedule 3, Indian Companies Act. Number 2, other documents required to be annexed according to accounts of company. Means P&L balance sheet, cash flow statement showing changes in equity, audit report, board report, everything you also attach. Along with that, normal company will file CFS. You also file CFS. Okay, you also file CFS. Sir, India we don't have company branch, sir. Parent company outside India will file CFS. That you file. If they are not in English, translation into English is mandatory. Next, along with the P&L balance sheet, other documents, CFS, you have to file 3 special statements. Related party transaction statement, Repatriation of profits means how much profits are diverted from India to outside India, how much amounts are transferred between countries. Audit should be done like a normal Indian company. Next, display of name etc. of a foreign company. Okay, three things should be displayed. What to display? Name of the company. Very good. KFC Limited or KFC Incorporated. Country of incorporation USA. If the liabilities of the member is limited, tell that liability is limited. Okay. I will tell name, country of incorporation, liability. Where I need to display? Three places you should display. Same like we read in register office clause. Outside every place of business. Very good. In all documents. In the prospectus. How? Same. Conspicuous, legible English characters and in local language in which it is place of business is there. That local language. Okay. Remaining questions not having any scope of asking in exam. Lastly is the prospectus. Okay. This one similar to your prospectus chapter only. Okay. See, a person outside India wanted to issue, circulate or distribute a prospectus for offering securities in India. He can do, but you have to file these documents. Okay. You have to give MOA, AOA, date of incorporation of your company, where your PPOB, where it is, all those same 380 type. Next, expert consent is required. Okay, expert consent is required. Expert consent not taken, don't issue that prospectus. Expert consent is taken, okay, but that expert has withdrawn the consent, but still in the prospectus I am showing as if expert consent is there. Don't issue even that prospectus. Third one, expert consent is given, he did not withdraw. You should tell that he did not withdraw, or else again it will become invalid, because telling a false is dangerous, not telling the truth is much more dangerous. Okay. And every prospectus require registration signed by direct chairman and two directors, approved by the board of directors, sent to the ROC for registration. This one 99% chance is there in the September exam. Don't cry once it comes. Okay, act before it happens. Easy enough, that's why I'm leaving for you. Just read the chart and leave. One question will surely come. At that time, don't cry. Next chance is penalty provision is there. Just read the penalty 392 and 393. That's it. With this, all the promised provisions, 4 chapters, I call them the fantastic 4 in law, I have completed as per the word given to you. Okay. With this, whatever the promise that I have made to you, I discharged it with the fulfillment. Okay. Now it is within you to complete the portion properly. Okay. From now, you should take a oath with yourself that I will be studying. From now, no video, nothing. Close YouTube, close Instagram, close all social media. Now your concept of 4 chapters is over. From now, if you start watching the videos, so your time will get wasted. So even this video also you completed, over. That's it. These 4 chapters you should not touch now. If you want only foreign company, whatever left concepts are there, just you revise them. Remaining, if you start watching, the time will get wasted. In 4 hours, as I promised, we completed everything. Now it's a final call for you. How you felt about the session here? Did you really feel it advantageous for you? Everyone? Did you feel the schedule to be advantageous to you? Okay. Thank you. 4 chapters we have completed. These 4 chapters, again, don't put a time to read. Don't waste time. See the schedule yesterday I have given. Follow that properly. That's it. Don't listen to any video now. Over. Time is up. Okay. We have completed the session. Thank you very much. All the very best for your examinations. Meet you in CA Final, AFM and Direct Access. Okay. We will be having a session like this also for FM. FM also will have a session like this. FM also will have a session. DT also will have a session. Okay. Thank you very much. Sorry, I am ending the stream. So thank you very much. All the very best. Prepare well for the exams. Give your best. Make your parents proud. Thank you. And happy Teachers' Day to all the teachers. Thank you very much.